Hear ye. All persons having any interest before the Honorable Justice, the Appeals Court, now sitting in Boston, Commonwealth. Draw near, give your attendance, and you shall be heard. Glad to the Commonwealth of Massachusetts, this court is now open. Please be seated.
Thank you. Good morning.
Morning. Thank you. Good morning, everybody. Happy December, and welcome to the first December sitting of the Appeals Court. It's Monday, December 2nd, 2004. Your panel for today is me. I'm Greg Massing. To my right is Justice, wait a second, Maureen, it's Walsh, right? And Justice Brennan on my left. We're hearing 6 cases today, 3 civil, 3 criminal, 3 civil, as we usually do. And rules are very simple, 15-minute per side, no rebuttal. We have read your briefs, so we are prepared. You don't have to, you can go right into your arguments. You're free to use all 15 minutes, but you're also not penalized if you finish early, if you've said all that needs to be said. We have in front of us these little tablet devices, which is where we have all of the briefs and appendices and transcripts. So if you see us looking at our computers, don't worry, we are not looking at our email or surfing the web. We are actually looking at your case materials. So with that, let me call the first case, 23P818, Commonwealth versus EMMANUEL Rivera.
Good morning, Your Honors. Tara Ganguly for Mr. Rivera. As Your Honors can see, this is a pretty simple case with a single issue, and that issue is, was Stephanie DeCaro biased at the time of trial to the extent that she could not testify as the first complaint witness? The case law is pretty clear in both Commonwealth versus Marungu, Commonwealth versus Stuckich, Commonwealth versus Asenio, that a voir dire should have been done here in order to determine whether DeCaro was in fact biased.
So can I ask you, at the very beginning of day 1 of the trial, the defense counsel had filed a motion to voir dire the first complaint witness, and like on page 4 of the transcript says, Your Honor, I'm withdrawing that motion. There's no need to voir dire the fresh complaint witness. Can you explain that?
I think that was before they really got into this particular issue, because they hadn't discussed the Commonwealth's motion for substitute first complaint testimony. I think trial counsel was talking about a different first complaint issue.
What different issue was there? Do we have that in the record? What that motion was for?
It probably is in the record. I apologize. I don't know exactly, but
he says, as far as the motion that I filed over the weekend for a voir dire of the first complaint witness, I don't think that under the circumstances that'll be necessary. And then he goes on to say, it's actually because this is a jury-waived trial.
he does say that yes.
So the point being, I suppose, if you're the judge sitting in the jury-waived trial, presumably you're expected, you can do a voir dire, not the best approach, but do a voir dire almost as you're going if you need to, separate it out, move it around.
I suppose, I still think they could have done it in a way that, sure, it would have been different than with a jury and, have to take the jury out of the courtroom and then question the witness. But the way everything sort of went down here is that both DeCaro and Valentine Primo, the grandmother, essentially gave 2 versions of complaint testimony.
Putting that aside, are you saying it is improper, and on the flip side that it would be mandated for a judge to do a voir dire if they get an email that says what this email said, or an offer of proof to just say, well, that's obvious?
The email he's talking about, the email where she basically says, I'm not going to, my daughter's a liar, I'm not, yeah.
I love you, sorry, I didn't mean the email, it's a text message, my apologies, right. I love you, call me as a witness, get your lawyer to call me as a witness, my lying daughter, I'm paraphrasing, but all of the above.
I think the problem is that she certainly sent that text message at some point close in time to the allegation, whether...
Well, do we know when was it close in time to the allegation or close in time to the trial? Do we have any evidence of when that was?
It's not in the record, so if you want to save yourself a few seconds,
Okay.
I didn't see it.
We don't have any evidence when it was.
But I think my point is that at some point before trial, DeCaro did change her mind about who she was wanting to testify for. You know, she and the defendant broke up at some point for good. There was some back and forth, and then they broke up for good.
And we know that from her trial testimony?
Yes. And she willingly testifies for the Commonwealth. She's not subpoenaed in, she's not, you know, she's not there under duress. It doesn't seem in any way. And she testifies for as a Commonwealth witness about what her daughter alleges happened with her mother's ex-boyfriend. So at the time of trial, I don't believe that any bias existed, or if it did exist, it should have been fleshed out more fully in terms of, okay, well, when did you actually change your mind here about who you believed and why?
But the claim that you're making now, I mean, really was not raised at the time of the motion to eliminate was discussed, right? The counsel didn't say, well, that's past bias. I'm not sure she's biased anymore. We should have voir dire and figure that out. Counsel didn't raise anything like that.
He didn't make, I mean, he objected to the Commonwealth's motion to substitute the witness, but counsel did not say, you know, let's voir dire her. He did not say that.
Okay.
All right, so your argument is made a little bit more difficult based upon the record that we have before us. But even if we're to accept that the judge, better practice should have perhaps, in hindsight now, conducted a voir dire, what's the harm? What's the substantial risk?
I realize that in a jury-waived case, the judge is more capable of determining these issues for himself. But even in jury-waived cases, we still delegate the fact-finding portion as separate from the legal analysis. And the court simply adopted the Commonwealth's assertion that Stephanie was biased. And given the sort of the small scope of the evidence in this case, you know, this was, the child made an allegation, there were a few witnesses, one police witness, no physical evidence. Having two witnesses come in and say, you know, she told me this, and both of them to some extent made it clear that they believed her, which is sort of improper. There was one exchange with the court where I think the grandmother said, or somebody said, oh, and when Stephanie and Mr. Rivera were coming to the grandmother's apartment to like try to take the child back home, and either the aunt or the grandmother said, you know, we believe her. That testimony was struck, but there was other testimony sort of weaved in and out of all of these witnesses' testimony that made it clear that all of the women, the grandmother, the mother eventually, and the aunt, who didn't testify but was discussed, they all believed the child. So,
Would there have been or was there a difference between the particulars that the child related to the mother versus what she told the grandmother?
not specifically, there was, because the prosecutor was focused on the grandmother as this is my first complaint witness, so I'm going to go a little more into depth as to what the child told her. Yes, there was more that was described there, but the mother still testified, you know, we sat down, Manu's in the shower, and
We don't have in the
told
record,
me this.
but
She
we don't
told
have
me
the
everything.
specifics in the record, right? We don't have the particular, I'm looking to see the statement or a police report
Not a police, no, not a
or a
police
statement,
report.
so, all right.
But Stephanie testified that her daughter, quote, told her everything. Or maybe her daughter testified, I told my mom everything. So in my mind, that means exactly what she ended up later that night telling the grandmother.
So again, if it's the same statement made close in time to a different person, and you're position, if I understand it, is that all the women believed the child. I'm having a difficult time understanding the substantial risk.
Well, I think it's prejudicial error because there was an objection to the substitution of the witness. So I think that would be it would be a preserved error as a standard of review. You know, essentially in a case with zero physical evidence, 2 complaint witnesses, in my mind, there is a risk that that constitutes a piling on of complaint evidence. I really don't have there's no further thrust of that argument, but that is essentially the argument.
So, I mean, if it had gone the way that you think it should have gone, the mother would have had more detail from the mother.
Mm-hmm.
The grandmother would still testify. We'd have no detail from the grandmother.
Correct.
Did the victim, did she testify that there was penetration? Because
This was a little unclear. She did testify that that his finger went in and out, so technically yes, but the judge certainly did not find that.
right, and the grandmother said touched her on the outside, right? So the grandmother's was not consistent with the victim's testimony, but actually was more consistent with the lesser included offense.
Yes, but I still think the mother's testimony, we don't know what the mother's testimony would have been. The mother could have, it depends how the child then, she may not know the exact difference between rape and assault and battery of a minor, so the way she testified, the way she spoke to her mother may have been the same way as she spoke to her grandmother. And then that may have been slightly different than the way she actually testified at trial. We just don't know. If there are no further questions, I'll rest.
Okay, thank you.
Thank you.
Good morning. May it please the Court. Assistant Attorney William Joyce on behalf of the Commonwealth. I'd just like to begin briefly, Justice Massing, with your last point about whether or not there was evidence of penetration. I'll direct the Court's attention to Volume 1, page 68 of the transcript. This is part of the victim's testimony where she did testify that the defendant, touched the inside and outside of her private area. So there is some evidence of penetration from her testimony. This is really a fairly straightforward issue. This is not the type of situation that required a voir dire because there was no issue of fact that needed sorting out. And the cases do say that voir dires are appropriate where there is an issue of fact that needs to be sorted out, such as...
Do we know, excuse me for interrupting you, but do we know, it's not in the email, see, I keep saying email, it's not in the text message, the copy of the text message, why no one gave us the date? Because don't you think it would be more relevant it was the day before trial as opposed to the day after the incident, a year or so before?
So it's not in the record, but I don't know how much help I can be there, Your Honor. This specific text message was provided to the Commonwealth by defense counsel. It was a text message from the mother to the defendant. I don't have any sort of date of when it was sent or when it was provided to the Commonwealth by the defense counsel.
Fair enough.
So when is the time frame we should be looking at the first complaint witness's bias? Is it the day, the day of the incident or the day of trial?
Well, it's going to be fact specific, certainly, and I will admit that it would have been preferable for the judge to have conducted a little bit more inquiry. It would have been a best practice. However, I don't think it was entirely necessary here, and the lack of a further voir dire is not damaging to the situation in totality. Certainly, the closer in time to the trial that you can show evidence of bias, the better. But in some level, the point of Marungu is if the first complaint, obviously the first complaint witness is to help the fact finder, in this case the trial judge, assess the credibility of the victim. And if there is evidence of bias, Marungu says, well, why should we take that risk that this witness is going to go up on the stand, having told the Commonwealth, yeah, I'm going to testify to X, Y, Z, it's going to match more or less what the victim is saying, and then they go up on the stand and they tell something completely different.
Not to get hung up on the date.
Oh, certainly.
I'm not, but again, it's clearly not in the record that we have. The text message is cut off in some way. But looking back at what the judge knew and didn't know and should have done or should not have done, do we have any reason to believe that the judge had some document that actually had the date on it and so could have made that determination, or we just don't know that? Without getting into the off-record specifics about what the date
As far
might
as
have
I'm
been.
aware, the document before the court is what was provided to the judge. There may have been some other texts. The assistant district attorney who handled the case couldn't quite remember whether or not she had attached those additional texts. This was the only one that she remembered for certain she provided the court with.
Is it your position then, though, that given the content of that text message, that regardless of when it was sent, the Commonwealth should not be in a position to have to risk it?
In this case, absolutely, Your Honor.
Why?
This is the proper first complaint witness text reaching out to the defendant in advance of the trial. Again, we don't know exactly when, but in advance of the trial saying, tell your attorney to put me on the stand. I don't believe her. I can't sit there during the trial and listen to her say all of these things about you. I think it's pretty clear that that's evidence of bias right there. The witness is saying, I want to be put on the stand so I can tell the court she's a liar. And again, even if she later changes her mind before trial and says, well, you know what, actually, after thinking about it, I do think she's correct, why should the Commonwealth be required to take that risk?
So if the judge had held a voir dire and the mother had said, well, yeah, I sent that text, but now I don't feel that way. Now I've changed my mind. Is your position that the judge still had discretion to say, notwithstanding that, still out, or that the judge really should be focused on what was said at any point in time, and that just demonstrates bias and it shouldn't happen?
I think your first option is the correct answer, where the judge is evaluating the credibility of the witness and saying, well, I know you're saying this, but I don't believe you in this case, which a voir dire might have helped with that. But there was
the fact that they kind of got a second first complaint out of the mother anyway?
To a minor extent, yes. I will say again, this is a jury waive trial, and Marungu does say that in that context, if there is a second first complaint witness that testifies, the judge is presumed to be able to sort out what is and is not proper, and I would submit that that happened here, given that the defendant was charged with aggravated rape of a child as well as witness intimidation, and he was acquitted of the witness intimidation and only found guilty of the lesser included indecent assault and battery of a child, suggesting that the trial judge did weigh the evidence. He didn't believe certain parts of the victim's story and did believe others based upon the totality of the evidence, which then goes to the issue of prejudice of there is no prejudice in this case. Even if the judge should have done certain things, even if he abused his discretion by allowing the substitution, there's no prejudice in this case.
So you're using the word prejudice as opposed to substantial risk of a miscarriage of justice. I mean, I guess your position would be either way.
I'm using prejudice as a blanket term,
Right.
Your Honor. I do believe that, or the Commonwealth's position is that this was not a preserved issue, therefore it should be reviewed for substantial risk.
And so there was a motion in limine. Why wasn't it preserved?
Again, this goes back to the point of this was not a factual issue. This was a legal sufficiency issue. The defendant's argument was, well, I know there's all this evidence of bias, but Your Honor, you shouldn't find that sufficient to allow the substitution. This wasn't a fight over whether or not the victim or the mother was biased at all. So the issue that the defendant is now raising is completely different from what was raised at trial. If there are no further questions,
Seeing none.
we'd ask this court to affirm the conviction and we'll rest on our brief. Thank you very much.
Thank you both. Very well argued, good briefs, nice and succinct. So the case is submitted. So calling the second case is 2024 P466, COMMONWEALTH versus CALORE. Mr. Curhan, you'll explain that to me.
I'm not quite sure, but I call him CALORE.
CALORE.
May it please the Court, Dana Curhan representing EUTICHIO CALORE. We challenge the sufficiency of the evidence on charges of possession of a firearm and ammunition. The jury in this case reached a rather curious result. They found either that he didn't shoot the gun or they had a reasonable doubt as to whether he shot the gun. And
Or maybe about whether it was 500 feet from a building?
I'm not sure. I'm not sure about that. The complainant, or the main witness, testified that it was less than 250 feet. So I don't think, I think it's from her house, and it was actually across the street from the neighbor's house. So I don't think that that was necessarily the issue. I think the issue is whether it was this defendant who fired the gun.
All right, isn't that really speculating? I mean, boy, if we're starting to go there. Could have been the 500 feet, could have been a compromise, could have been you had some jurors who said, not really convinced here, and then traded off votes. We don't know, right?
I mean, it's possible. We just don't know. If
Right.
they had convicted of discharging a firearm, I would be arguing sufficiency of the evidence on that charge.
For sure.
You know, certainly,
But just the fact that the jury found him not guilty of one doesn't mean that really, it seems to me, informs us so much on their analysis of the other.
well, I mean, here's the problem. The main witness said that she saw, I mean, she identified the driver as wearing I think she said a white puffer coat. The arresting officer said it was gray, but enough evidence that that was him. He was the driver. She saw somebody's right hand reach out on the steering wheel with the gun, and a left hand cocked the gun. Now, the defendant could have been sitting there and saying, okay, gun goes here, I cock it, I reach out the window and I fire it. Alternative scenario, the passenger who actually had the gun when he was at the time of the arrest and had a license to carry, he could have reached out across the steering wheel, cocked the gun, stuck his hand out the window and fired it.
But that's not the standard that we view the sufficiency of the evidence argument, correct? I mean, what could have been, I mean, when, it's a different standard, right?
Right.
Okay,
And-
so when we look at the light most favorable to the Commonwealth with all reasonable inferences drawn therefrom, how is it then, not what have, could have been, should have been, with what we have kind of on the scales? We've got somebody identifying that truck, the clothes that the defendant's wearing. I understand that there was inconsistent statements about whether he was a light-skinned Hispanic male or not. We have the videotape of the audible bang. Shortly thereafter, we have the police officers seeing the defendant hand something to the passenger. And, of course, the witness's testimony about racking the gun. So why is that not sufficient as evidence?
Well, because I think it is speculation that the driver fired the shot and was holding the gun as opposed to the passenger. You can't, I mean, maybe he did. Maybe he didn't. You can't tell.
Was there any evidence on what I don't remember that if there was, that what the passenger was wearing? Whether the passenger had a puffy jacket?
I don't think there was. Nobody said anything about a puffy jacket.
Would have been helpful.
You know, the problem was, yeah, we'll concede that he was driving. My client was driving. We will not concede that he fired the gun.
My understanding was that the arm that came out the window was within the puffy jacket, but maybe I just read too much into that.
I think you may be reading too much into that. I think that's what the Commonwealth's contention is that the witness identified the driver as the shooter. She did not. She said she saw an arm coming out. On cross-examination, I think I said volume 1, page 154. It's actually page 155 that she answers the questions on 154, and she says that he was lighter skinned than the arm that she saw. So, you know, but again, in the light most favorable to the Commonwealth, we probably disregard that, but still, you can't tell who shot the gun. Now, I think the jury came to that conclusion. They at least had a reasonable doubt that he shot the gun. But based on the officer's testimony that when she was pulling up behind them, she saw the driver appear to pass something to the passenger, I think that's probably what the jury may have fixated on. Now, here's the problem. There's a line of cases from the SJC and a few from this court that say momentary handling of a gun is not sufficient to establish possession. The Saya case that I cite in the brief, it says, carrying a firearm occurs when the defendant knowingly has more than momentary possession of a working firearm and moves it from one place to another. Commonwealth versus Atencio, which I did not cite in the brief but is cited in Saya, 345 Mass 627 at 631, says that momentary possession during a game of Russian roulette is not carrying. I think what that means is that if, when the officer pulled up behind them, the gun was sitting on the console, and the defendant picked it up and handed it to the passenger, that's not enough. I think only if he took the gun, fired it, and maybe put it in his pocket and then handed it over.
I know we're speculating, we're getting into even more speculation, but if the gun is sitting on the console of a car right next to the driver, couldn't one infer that that driver had the intent and the ability to exercise control over it, given the circumstances here? I mean, so there'd be a constructive possession argument. We're not going to go there, but I'm not sure that these cases really fit this case. But
I don't think we can get there, because I think we're speculating that it was actually on the console.
Right.
What he handed was the gun.
my point.
And
So I
even
think
if-
it relies on the theory that he was the one who shot the gun.
Right, even if it was sitting on the console, the passenger lawfully possessed that gun. So, you know, to say, you know, maybe it's a joint venture.
Well, unless the passenger took it off the console after the driver shot it and momentarily possessed it before the police stopped him. So that's why I think we kind of
If
don't
he
engage in
picked it up off the console and handed it to him, then that line of cases, Saya and the other
Fair enough.
cases, I think they apply. And we just can't tell. I mean, we can't tell where we are. We can't, the evidence it supports a hunch and no more than a hunch. And
There's some video, right, that was presented at trial. I don't think we have it. I don't think anybody submitted it for us. What did the video show?
I think the video showed the truck. I don't think it. I don't think it showed. You know, the witness said the windows were tinted and she couldn't tell that there was even a passenger. So, and I don't think the video conclusively establishes that this defendant fired the gun.
Is it her Ring camera or something? Or what does the video
I
come
think
from?
it's somebody's Ring camera.
The neighbor across the street, maybe?
I think the neighbors, and then there's her camera, which gets her, you know, gets the audio of the bang and her running in and saying, "Everybody get down." I don't think that really shows anything.
But, I mean, when you look at, and I'm referring to the testimony on page 140 of the eyewitness. I mean, despite the fact, again, it's the light most favorable to the Commonwealth about tinted windows and maybe this was a who knows who. I mean, she testifies at one point the driver's side window starts to roll down. I can see the silhouette of a person. I can see the steering wheel. And then the next thing I see, a hand go up on the steering wheel. She says like this, which appeared to be a gun in his hand. And then she goes to describe that he has a gun and what he's wearing, the puffy jacket with the furry hood. I mean, this is not a situation where she sees someone reaching over or two by. She sees a silhouette, she says. and she sees the hand out the window?
I think even in the light most favorable to the Commonwealth, I think that's inconclusive.
Okay.
And, you know, again, the jury did not find that he fired the gun. And the jury probably found, or hard to speculate, but may very well have found, based on the officer's testimony, that that was the gun. Now, the jury was not instructed on momentary possession. I don't think anybody saw that as an issue, and there's no objection. But, you know, if he was only charged with possession of the gun and ammunition, that would have been an appropriate instruction. I just don't think anybody thought of it. But in any event, it's our contention that there's just not enough evidence to establish his guilt beyond a reasonable doubt.
Okay, thank you.
Thank you.
Good morning. May it please the Court, Benjamin Haspel, Assistant District Attorney for Middlesex on behalf of the Commonwealth, and for the record, I was also the trial lawyer on this case. The facts that were presented at trial and the Commonwealth's position here is that there was evidence, direct evidence, of a witness who testified that she saw the defendant holding and possessing a firearm. As Your Honor just alluded to, that testimony, page 1, or volume 1, those pages 140 to 141, she actually describes that she sees the window of the driver's side go down. She describes the individual with his left hand, so on the left side of the car, pointing a firearm or a gun. She says that he makes a racking motion with his right hand. She describes the individual wearing a gray parka jacket with a fur hood and driving in a vehicle, and the video shows it's the house next to at 24 Windsor Street, shows a distinctive pickup truck. It's a black cab with a white bed pulling up and then actually reversing back down the street. There's no video of the shot being fired, and so to the extent that there was inconsistent verdicts in this case, the case law is abundantly clear, both in this Commonwealth and from the United States Supreme Court, that inconsistent verdicts won't disturb unless they're factually inconsistent.
You're basing the possession on the cocking of the gun in the driver's seat, not on the passing it to the...
Right, and correct. When he actually pointed the firearm, there was testimony out the window that was possession. That's dominion and control. In the couple of cases that we cite in our brief about this was more than just, hey, can you pass me that, and him passing over. I agree that the case law there would suggest that that's momentary possession, but to actually exercise dominion and control, possess a firearm pointed out the window of the car.
And to Justice Massing's earlier point, I mean, for all we know, it was the 500 feet that was an issue on the second charge. They just didn't necessarily credit that she could estimate a couple hundred feet versus 500 feet, or I mean, we don't know.
And that's exactly the point, and that's exactly why I think courts universally really disfavor this idea and reject this idea of inconsistent verdicts. It could have been the 500-foot issue. It could have been the consent of the homeowner issue. It could have been that the jury, they're exercising their democratic power of leniency, decided to acquit of discharging a firearm, but found guilty verdicts for the possession. And so the issue before the court is just then, is there enough evidence that the defendant possessed the firearm?
I was trying to find that where it says 250 in the transcript, and I couldn't, but actually what she said was 25 feet.
She says it was very close. There was also...
That's less than 500, isn't it?
That's less than 500.
There was really a lot of evidence. One of the officers even was there and took photos from the end of the street. There was map testimony. There wasn't a ton of evidence. There was also argument that 300 feet is the length of a football field. That's further than Fenway Park to the furthest from home plate to the fences. That I don't really think 500 feet was the issue, but it highlights the point that I don't think that courts are in positions to upset verdicts when you have inconsistencies like this, because it would just be speculation as to what the jury did. And so based on that, there's the other corroborative factors to the extent that there was a loud bang that was heard on the video footage, testimony from a state police ballistician, a sergeant, that when he actually test-fired this firearm, it caused a loud bang, that when a shot is fired, the shell casing discharges back into the right. A shell casing was found underneath or on the back right passenger seat inside the truck. The argument was that when the officer testified that she saw the driver passing something over, the argument at trial was that a firearm, if he was passing it, would probably be much lower. This was a large pickup truck. Instead, what she may have seen the officer was the defendant placing a sweatshirt over the shell casing, thus implying consciousness of guilt that he had knowledge that the shell casing was back there because he just possessed the firearm and fired it. So I do think that there's sufficient evidence here to establish that he actually possessed the firearm and ammunition. Okay. And if there's nothing further, I'll rest on my brief.
I'm all set.
Thank you both. Again, good succinct argument. Case is submitted. So we're going to hear cases 3 and 4 before we take our customary break. So we'll hear the last criminal case and the DCF case before the break. So next is 23P 373 Commonwealth versus William Lopez. Just a sec.
Good morning.
Okay.
Jean Liddy on behalf of William Lopez. May it please the court. This is a case of prosecutorial misconduct, and the facts of the case are pretty short, but the errors are long. And cumulatively, I think the best way to tell the story about what happened in the trial is to talk first about the opening and the improper nature of the opening. Not only was it argumentative, but it had personal opinion, interpreted state of mind, and
Can I just let me just put it on the table here.
Sure.
All of your arguments go to the claim of trying to disarm a police officer, and the jury acquitted of trying to disarm a police officer. So why is any of this prejudicial?
To your point, I agree. That's exactly what happened. However, the entire trial was about disarming, from the opening to the manipulation, which was a key word in the trial, to the state of mind. And because the entire trial concerned attempt to disarm, even in the Commonwealth's brief, they talked about some of the evidence and you know what that meant during the course of the trial. I think that was on page 24 and 26 of the Commonwealth's brief. So yes, he was acquitted of attempting to disarm, but the trial was about attempting to disarm.
So again, I'm not sure I've heard why we're here. I have no idea why we're here on this case. None whatsoever. Zero. So please enlighten me. He was found not guilty of that. Are you saying it infected the trial so much about the disarming part that they found him guilty of driving 125 miles an hour, running from the police and smashing into a guardrail? I'm missing that connection.
Well, I would suggest, I understand, to your point, I would suggest because it opened up in that kind of a flavor, and the trial was about that it became a merger. And I think I addressed the merger aspect of it with ABPO and the delineation between general and specific intent. And I think because of the evidence, the way it came in, that it was muddied to a certain degree, and that it was inevitable, even though he was acquitted on that, to your point, it was inevitable that he was going to be found guilty because the facts were merged and the proofs were merged. And that would be the thrust of it.
So because the judge failed to give a specific intent instruction, although the judge did instruct on intent as it relates to attempt to disarm a police officer, and because the jury rejected the Commonwealth theory relating to that intent.
Well,
Take me to the next step. I'm still
Sure,
missing
sure.
it.
No, it is difficult. I think in this case, because it was improper throughout the course, and because you have to look at it cumulatively, and I know that the Commonwealth talked about CAPIA, and I stress NIMIC, that it was a cumulative effect. And because by the time it got to the jury, and it became a merger of the different types of intent, and I believe the jury struggled with that.
So worst-case scenario, it's a general intent, and they misunderstood, and they say, oh, this is a general intent crime, and they found him guilty of only general intent crimes.
Yes.
Okay.
But it was a general intent crime, wasn't it, that they found him guilty of?
Yeah. Right.
I mean, and actually, wasn't it defense counsel who sort of muddied the water by talking about specific intent in the closing?
He did, but I think at that point the damage was already done because you had so many different opinion and subjective testimony and errors of the evidence throughout the course of the trial that
So
everything
let me
was
ask you,
just a
let's
big
talk about the
tangled
facts.
mess.
Let's push this aside for a moment, so we know nobody else wants to ask more about this. But on the facts themselves, are you suggesting that the trooper's experience in the military, when the defense is, well, he was so, his stress level was up and his heart rate was going a million miles an hour, and that's why he affected his perception and understanding, that his experience being in combat and understanding how he holstered his gun 10,000 times wasn't relevant or probative of anything?
Well, again, that would be another aspect that I would suggest would be improper, because what was the purpose of that, other than...
To demonstrate that he actually had experience that would perhaps offset a rookie first-day-on-the-job police officer's greater likelihood of being thrown by the situation or heightened, if you will, I think, as the defense argued. Right?
Well, okay, so
I suppose
speaking...
not to trivialize it, it's like, is it some one day in the NFL quarterback behind there, or is it Tom Brady? Do we care when we're saying, who's likely to be more successful in this situation?
Well, that's an interesting point, because in this case, it's stressful. Obviously, you're tussling with someone on the ground and, you know, this is going on. That's stressful. What was the purpose of bringing in the Afghanistan testimony that occurred a long time ago in a different situation with a different weapon? It was only to heighten, to kind of, and you go back to the beginning of the trial and the end of the trial, where it was suggested that the defendant was making his way across the gun belt, you know, and manipulating, and this was a theme. And, you know, I'm suggesting that standing alone, as Your Honor points out, is not enough, but taken cumulatively, as in NIMIC, would be enough in the totality of that.
You got a difficult case, right? Lots going on in this case, but you're throwing in totality and cumulative and number of different phrases. It seems to me that if I were to accept for a moment your position that all of these errors happened, they happened on the charge still that the jury acquitted your client of. And so it seems as if, even if we were to accept error, whether it goes to prejudice, it just zeroes out, doesn't it? In other words, it's a different charge, it's a different instruction, and different facts. And I don't see how that would infiltrate or poison the jury in deliberating separately, as they were instructed to, on the other charges. So cumulative error, even if I agree error, acquittal, it seems like you close the door.
And I understand Your Honor's point. I would suggest perhaps looking at a case I cited, which would be, I think it was Cater, and it talks about, would the errors have made a difference? And I think that the key here is we don't know. We don't know because the matters were merged. Even though, yes, he was acquitted on some of those things, it was so tainted and so improper, and there were so many errors.
Why do you say the matters were merged? That's my difficulty in understanding.
I think because the entire trial, again, the entire trial was about disarmament. Not so much the assault and battery of a police officer, not so much the other facts. And I think, at what point is it where a prosecutor is coaching a witness and setting the stage for some of the evidence that came in, I would suggest improperly. So yes, the jury exercised their discretion, and they they weighed it, and sometimes, as we know in a trial, they'll come out, they'll split it, and they'll say, well, I want to find him guilty of something because something happened.
Let me try a simple one at least, maybe one. Can we all agree that there was no motion for new trial, that this was a motion for required finding of not guilty, and that it was a sufficiency of the evidence, not a motion for new trial?
Yes.
Okay, we're on the same page, at least on one thing.
And I guess if there are no more questions, I would rest at this point.
Okay, thank you.
Thank you.
We'll hear from the Commonwealth.
May it please the Court, Emily Mello on behalf of the Commonwealth. Here, the defendant makes a myriad of claims on appeal. Every single one of those claims goes to the charges of attempting to disarm the police officer, specifically with respect to attempting to disarm him of his firearm. As the Court is aware, the defendant was not convicted of that charge. He was only convicted of the lesser included assault and battery on a police officer. The only claim here that could, I think, be even remotely construed to pertain to a judgment against the defendant would be the claim with respect to specific and general intent. I would just point the Court to a couple cases. Those would be DeShane, Moore, and Gunter, which are all cited in my brief. I think that DeShane, even though it's assault and battery on a court officer, does the best job of explaining that when you have assault and battery on a person of a specific type, the additional elements there are the knowledge of the person is a specific type and that that person is engaged in their duties.
Is attempting to disarm a police officer, in your view, a specific intent crime?
I would say, in my view, attempting to disarm a police officer would be a specific crime and a specific intent crime. And the reason for that is because specific intent looks to purpose, general intent looks to knowledge. When you are attempting to disarm a police officer, you are doing it with that specific intent and purpose of disarming him. Okay. But I would point the Court to Gunter, which says that it basically describes the common law confusion between specific and general intent and goes on to then say that the Court does not need to instruct on specific and general intent so long as it properly instructs on the elements of the crime, which the judge did do here, and the defendant does not suggest otherwise in his brief or suggest any other instructions that should have been given. And again, I would just go back to the fact that all of this and every single claim in the defendant's brief really goes to attempting to disarm a police officer for which the defendant was not convicted.
Can I just ask, though, just one thing about that? In the closing argument, the prosecutor says, the trooper, I don't say this to bolster his credibility or make you, consider him a hero. I mean, isn't that exactly what she's doing there? It's like using it to bolster his credibility and have the jury consider him a hero?
No, not at all. And I think that that is specifically why she pointed that out, because she wanted to make clear that the evidence about the fact that the trooper had been in Afghanistan and that he had been in combat and that he was very familiar with semi-automatic weapons and had used semi-automatic weapons in Afghanistan was that evidence went to rebut the defendant's evidence, which was that because the trooper was in this heightened state of being nervous under the circumstances, that he improperly bolstered his weapon. So I think that evidence was actually really important. And then I think it is, sort of kudos to the prosecutor for going out of her way to say this evidence does not go to the fact that he is more credible or that he's a hero. It goes to the fact that he has experience in high-stress situations dealing with firearms. And then again, in any event, the defendant was not convicted of that charge. And if there are no further questions, I would rest on my brief.
I have a
Oh, I
question, maybe,
apologize.
and maybe I'm lobbing it, but do you have any thoughts on what some might perceive to be just a gratuitous array of arguments about prosecutorial misconduct?
I apologize, could you repeat that?
Do you have any thoughts on what some might read to be a gratuitous array of complaints of prosecutorial misconduct?
I mean, I do think here that the defendant kind of picked out every single thing that the prosecutor said and did, none of which I think was error.
Did any of them come close?
Yeah, I think that her opening was entirely, and she actually said, this opening is an overview of the evidence that I expect to come in. And then she described some of the things that the witnesses would say, and all of those things the witnesses did say. And the same thing in her closing. She's marshaling the evidence to convince the jury of her theory of the case, which obviously they did not accept, but I don't think that the prosecutor did anything even approaching error. And in any event, as I said, the defendant was not convicted
There's no
of the
claim
charge.
of ineffective assistance, but it seems some implicit argument that the defense was somehow misguided. I guess you don't have to defend the defense attorney in this one, the trial lawyer, but it seems to me the defense attorney found a pretty good angle on the defense, focused in on it, and got what they could out of this case. But
I think in this case, the defense attorney actually got what he was seeking to achieve. Even at the trial, as my sister counsel said, everything was really focused on that attempting to disarm charge for which the defendant was not convicted.
I guess I have nothing.
Do you think is there I mean, as a way of looking at it, so defense counsel didn't object to any of the stuff that's in the brief now, and is it maybe actually defense counsel thought that was actually helpful to let the prosecutor sort of overdoing it and that might actually not help with the jury?
I don't think that the prosecutor was overdoing it at all. I think that the prosecutor did a really fantastic job here. It just didn't turn out our way, which often happens. I think that the defendant did not object because the prosecutor was not doing anything objectionable. And if there are no further questions, I would rest on my brief.
Okay.
Thank you.
Thank you. So that case is submitted, and so we're going to hear one more case before our customary morning break, and that will be 24P98, Department of Children and Families versus Father. And I probably don't need to remind experienced counsel here that this is an impounded case, so we'll not refer to anybody by name.
Thank you very much.
Good morning. May it please the court. My name is Alan Campbell, and it's my privilege to represent Father in this case. Father is asking in the first instance for a remand for a new trial as to the question of fitness and termination, or in the alternative for a remand for a new hearing on the question of ongoing visits with his son.
I wanted to ask you about the remedy. Would it be for a new trial, like new evidence, or just new findings of fact from the judge? I mean, if we agreed with you that the judge had erroneously shifted the burden, would the remedy be go back and take a look at it, applying the correct burden?
I think you would have to have new evidence. This trial was 1.5 years ago, which in the life of a child and of a parent is quite a long time. And the issue is always current fitness. So looking at evidence from, again, 1.5 years ago wouldn't be deciding Father's current fitness. So
Right, but isn't this really a legal issue, and then the vehicle to get to current would be different than going back, it seems to me.
It is a legal issue.
Odd,
If
yeah.
the case had gotten up here in a couple of months, it probably would be okay just to reconsider it with the proper standard. But again, given the passage of time, I think it would be doing more than a disservice. I think the argument is based on a due process violation. I think to then say, well, okay, well, a year and a half has passed, your life is different from what it was, but we're still going to rely on the previous facts. You can't make a determination of current fitness from facts that are a year and a half old.
So where did the judge get it wrong?
The judge got it wrong in finding, or conclusions of law 4, 5, 8, 15, and 16, where the judge 10 times, or approximately 10 times, used language such as father was unable to demonstrate, has still not shown, unable to demonstrate progress, failed to show growth, did not demonstrate an ability to recognize and distance himself from domestic violence, has failed to demonstrate he's an appropriate caregiver, has not shown that he's benefited from services, has failed to demonstrate insight into various things.
Can they not say that without shifting the burden? In other words, aren't those factors still fair game, but the judge can't shift the burden?
Well, if it starts to get into a little bit of semantics. Certainly, the judge can mention on occasion what father has demonstrated and has not demonstrated. But to go through a litany of, say, father has not demonstrated this, he has not shown this, he has not shown that, I find that the DCF has proven by clear and convincing evidence that he's unfit and that the right should be terminated. Just using the proper language in your final summation does not mean you applied the proper burden. If all of the critical underlying facts you required father to establish, then DCF has not met its burden.
What if the judge, and I have to look back to see exactly how it was phrased, but what if the judge says, I find by clear and convincing evidence that DCF or the department is satisfied its burden, and that's because they showed this and the father showed this, they showed this and the father didn't rebut it well, so I accept this. They showed C, and the father, again, didn't disavow me of any thoughts as to that is incorrect. That's not shifting the burden so much as comparing the presentations. If the father hadn't testified, I think you may be in a different place perhaps, but isn't that just a comparison of the evidence and another way of finding what's credible, what's not credible, what's a fact, what's not a fact,
That's
through
not,
poorly
not
choiced
what
language?
happened, though. And father doesn't take on a burden simply by testifying.
No, but I mean, doesn't everyone who testify inherently have the burden of speaking truthfully or reporting accurately or if in a context, if a fact is proven by one, disproving it enough so that I don't accept that fact?
Well, you've touched a few things. Certainly you have a duty to testify accurately. The judge, numerous occasions, found that he did not credit father's testimony. Right. We've not challenged that. That's a proper role of a fact finder. Although it is interesting that the only fact that the judge seems to have credited that came out of father's mouth was father said, mother reported me to the police.
That's fair. And
the judge then credits that report, which is based on a witness who he otherwise has not believed a single word out of his mouth. But the judge didn't do what Your Honor has just suggested, and if he or she, I forget off the top of my head, if they had done that, I wouldn't be making this argument. And this isn't a Terrence case where it's two instances of mentioning it in the findings. This is repeated, requiring father to show these things. The proper language would be DCF has shown that father did not benefit from services. And this isn't just a semantics or a linguist. That's DCF's burden. Father has no burden. And if father says something and the judge doesn't believe it, that's no proof of the opposite. It's just not belief of what he said. DCF still has to prove that he hasn't benefited. And frankly, I don't know how you could prove that his parenting skills hadn't improved with the services, given he wasn't really provided a lot of opportunities to parent. Granted, he wasn't as consistent as he could have been with visits, but the visits all went well. That's from the DCF social work. I believe the quote is pretty well. And as your honors are aware, if things don't go well during visits, we hear about it repeatedly. So the fact that the only description of the visits that we have is that they went pretty well means the visits probably went pretty well.
So you keep saying that it isn't just semantics, but of course, it largely is semantics, but why is it not semantics?
Because the repeated nature of it, and especially in conclusion 4, when he just goes through at length at what father hasn't done, the implication is clear, is that the judge is putting a burden on father to not to be a good parent, but to establish that he has.
But can I interrupt for a moment? Would your argument hold true if the judge wrote on some of these, in fact, father has demonstrated X, Y, and Z? That's not appropriate? So in other words, not in all of them, but in a mixed finding. You know, part of your issue was that the judge didn't believe a word my client said when he took the stand, except for the one little bit that said when he got in trouble. But my point being is that if a judge in a thoughtful decision went through and said, on this issue, actually the father's demonstrated great insight in this and that, but on this one, father hasn't demonstrated this and that. Is the positive okay for the judge to write, but the negative not okay?
Well, the father has no burden at trial on this issue.
Okay,
So if father,
it's a burden, right? So
if father does something, that's great. Of course, the judge can comment on it. But what the judge can't do is require him to do so by pointing out all of the things that the father should have done if we were going to be finding him fit.
Can I ask, so what if, I'm reading, for example, father has not shown any consistent improvement in his ability to address the department's concerns? That's not, you think that's not properly phrased, or is that not one of them? Or
The proper, if the judge...
So what if the judge just said, father has not consistently improved? Without describing the source of the information, which is the father's testimony or the department's testimony that suggests it. Is that so that's the issue, right?
Given without the full context, I can't say if that would be perfectly fine, but it certainly isn't the same level as we have here. And
So father doesn't have to prove that he's fit. DCF has to prove that he's unfit, right? I mean, that's true, right? But that doesn't, not to say that father doesn't have to do anything. It's like father does have to, right? Father does have to participate in programs. Father does have to visit. Father does have to go to the batterers program and learn about not to do domestic violence, right?
Yes, and that's why it sounds semantic because because of the language being used, but it's actually deeper than that. And I agree 100%. If father doesn't do anything, I shouldn't say that. If father doesn't do anything, DCF is going to have an easy time proving that he's unfit.
So again, so let me just try this one. Father was unable to demonstrate progress regarding domestic violence, failed to show growth or apply skills learned in batterer's course to his life. Take that sentence.
Yes.
All right. You take issue with that sentence.
I do.
All right. And if the judge wrote, father did not make any progress regarding domestic violence, and father did not grow or apply any skills learned in a batterer's course to his life, that would be okay?
As long as the context showed that DCF was required to prove that.
Well, if they started the sentence, which she did, I think it was she, and all of them with the kind of boilerplate language, if you will.
Yeah, I don't think...
She just chose bad boilerplate, it seems to me, for a lot of
And each of these, I don't think he started this one. I have one quote here from finding 5. The quote is, at trial, father failed to demonstrate.
Yeah.
Which is, it's just the wrong language. And I know it's an unpublished decision, but in Dina, in that one, the judge found that mother could not meet child's special needs. It was reversed because the court hadn't addressed whether DCF had proven that she couldn't meet the child's needs. So,
Tell me again on finding of ruling of law number 5, what's the issue? What's the language? So I'm looking at it right now.
unless I've quoted it wrong, I have it as appendix page 71, conclusions of law 5. At trial, father failed to demonstrate into the potential effect of domestic violence on the subject children and into his own role in domestic violence concerns. Father has not demonstrated an ability to keep the subject children safe and the home free of domestic violence were the children placed in his care.
Okay.
That is a burden-shifting conclusion of law. The relevant thing would be DCF, at trial, DCF proved that father did not have insight into this, and DCF proved that father does not have an ability. When you, again, in Terrence is the case, I think it was 2 references in the findings, this court said that that's not a problem, it's not burden shifting. This is a substantial number of them. It's not just 1 or 2, it's repeated. And I think, as in Jace, we really just don't know whether the proper standard was applied or not. I should be clear, the proper standard is stated several times. So it's not just an improper standard is used in this case. Because of the proper and the improper and the way it was done, we don't know which one was actually applied.
What could you got 2 minutes and a half left. What about the argument on visitation?
So in visitation, the abuse of discretion here was in limiting the judge's consideration of the question of visitation was limited to whether or not there was a strong bond. And the judge found there wasn't a sufficient bond to warrant visits. I'll leave it to the discretion of the pre-adoptive parents. But we know from Vito and Rico that the presence of a bond is not the only factor. It's obviously an important factor, but it's not the only factor. I think Vito has the language that other circumstances of the actual personal relationship. Enrico also mentions that they may benefit from contact even if at the time of the decision they didn't have they hadn't already formed a strong bond.
So how would this child or the 2 children benefit from contact with the father in transitioning to their adoptive family?
Well, as I mentioned in the brief, there are a couple things. One is that mother has visits, so the children might be confused by having visits with mother and not with father. And then also father is Haitian. So like a Haitian from Haiti, not a distant Haitian. He has cultural traditions to pass on to his children. And I know that the pre-adoptive parents say they're open to cultural exchange or that, but Haitians are not fungible. Everybody's experience is different, so just saying, well, we'll find a Haitian, it's not the same as hearing about your own family history and tradition. And again, given where the visits went well, had the judge looked at it properly, I believe that some contact would have been awarded.
Okay, well, thank you. You finished just under the gun, so we'll hear from, I guess, the department first.
Good morning, Your Honors. Can you hear me okay?
Yes. Yeah.
William Cuddle for the department. Can you please let me know when I have a minute left of my time? We're splitting.
Sure, yeah. We'll give, I'll tell you when it's a minute and a half. That's when the yellow light goes on.
We're asking this court to affirm the decree. Before I get into my argument, I just want to point out a very important fact here. Father does not challenge any of the 116 findings of fact that show clearly and convincingly, as the court found in conclusion of law 3 and conclusion of law 29, that father is unfit and his rights should be terminated. There's no burden-shifting argument here at all. The Terrence case is squarely on point here. The court uses language, not support. It's all there before you. It's in our brief.
Well, I mean, the Terrence case was only 1 or 2 references, and here it's repeated references.
And this is 10 references in a matter of 42 conclusions of law that take up 18 pages. The father's unfitness in this case is overwhelming. That's why father, in good faith, couldn't argue against it. There's evidence before the court through 24 exhibits entered by the department. 2 witnesses by the department testified. The social worker, the adoption worker, father testified for the department. Father testified for himself. The findings, as you can see, are all supported by record sites or testimonial sites.
Attorney Cuddle.
Yes.
No, go ahead.
Judge Brennan.
Sorry, so I don't understand. I want to make sure I understand your argument. that you just started out with, which is father doesn't challenge any of the findings of fact. So if father doesn't challenge any of the findings of fact, then do the conclusions of law, the language of the conclusions of law, does it really matter?
Well, it matters in terms of how the court summarizes those findings, which is exactly what the court did in this case, as the court did in Terrence. The court used that language to summarize father's unfitness, what the past evidence of his neglect of the children, which came in through 51Bs, the evidence of his domestic violence with the mother, which came in through criminal charges, the restraining orders that he violated throughout the case, the testimony of the social workers, and the other documentation that showed that father didn't participate in all of his services. The court did find that father partially participated in services, but he didn't benefit from any of them, and he didn't participate in the services that most mattered, like the batterer's course. You know, interestingly, in this case—
Can I just stop you for one second?
Certainly.
I think I got you on that one, but unless, did that
That's great, thank you.
answer your question? Is your position that the language that was used, father did not demonstrate, father was unable to demonstrate, father failed to demonstrate, that language is perfectly fine in context, or is your argument that, you know, percentage-wise, it was only a small percent, and even if it wasn't 1 or 2, it's only 10 out of 300?
I'll be very clear.
With the inflection that I'm giving you. Which is it?
It's both.
Okay.
First of all, the language used by the court is perfectly fine. There's no issue of burden shifting through the language. And secondly, the evidence of unfitness is overwhelming here.
Okay. I guess put it this way, if you were teaching an MCLE on how to write these, would you have, say, write it like this, or would you say maybe choose some different words here?
I wouldn't say that, to be honest with you, because I've been doing these cases for 20 years, and oftentimes the conclusions of law are written this way. I give credit to my brother for pointing out this argument, because quite honestly, it's the only argument that he could make in this case, in my opinion, based on what I've written in the brief. The language is totally appropriate. It's a summation of the evidence. And even if it's not, and I do not concede that at all, as I said earlier, there's 18 pages of conclusions of law that the court made. These are 5 conclusions in some language in those. The evidence of father's unfitness stands on its own outside of those words, the semantics, and they are semantics in this case.
Thank you.
This isn't a close case.
Well, I guess I'm having a little bit of difficulty kind of parsing out, it's either burden shifting or it's not, right? And if it's burden shifting, then I don't think I can substitute and say, well, there's a lot of bad stuff in this opinion that was good, was written without the burden shifting language. If there's a burden shifting going on here.
It's not burden shifting, Your Honor,
Right.
with all due respect. The court, if you look at the,
I'm not saying it is, but I'm saying it seems to me that you can't have your cake and eat it too, right? It's either burden shifting or it's not, and if it's not burden shifting, then there's certainly quite a bit of evidence that was presented about unfitness.
it's not burden shifting, and there's clear and convincing evidence of father's unfitness, as you can see in the court's analysis of the 210 factors. There's 14 factors, as you're well aware, that the court has to consider. In this case, the court relied on 7 of those factors to support his determination.
Yellow light is on, 1:30.
To support the determination that father's unfitness is subject to termination of his parental rights. If you have no questions on that point, as far as the visitation issue is concerned, the court found there was no bond with the father and the children. The father missed a lot of visits due to being incarcerated. The children, even though it wasn't evidence, but it was taken for state of mind, made it clear they did not want to have visits with the father. And I'm sure my sister's going to go into this, but the pre-adoptive family were dealing with the heritage issue for the boys, so there was no need for visits. And it's really up to the pre-adoptive parents to make those decisions for the children. I'll rest on my brief. Thank you.
Okay. Thank you, Attorney Cuttle.
Morning, Your Honors. Amy Dodonna, excuse me, on behalf of the appellee children. Justice Brennan, I do want to take issue with something that you said when you were asking a question. You mentioned boilerplate language. So I don't think this is boilerplate language. And the way that I see it, Your Honors, is that the judge clearly told us that she understood the standard. We know that she understood the standard. She understood the facts. She clearly articulated the facts over, I believe, 44 pages of her decision. What she gave this father was an opportunity to rebut what she had already found, which is that the department had presented evidence of clear and convincing evidence of unfitness. So this was Dad's opportunity to step forward and say, actually, I did do that. I did do this. I did do that, which presumably is the reason that he was on the stand. It's risky for us as attorneys to put parents on the stand in those kinds of trial-type circumstances.
So just to kind of clarify one point, which is I'm not suggesting Judge Keating used boilerplate language. I was saying to the extent that this is just boilerplate doesn't make a difference. But I may have not articulated that, but.
I just wanted to
That's
be
fair.
clear.
No, that's a fair shot. Coach, come at me on that.
My perspective that not only was this appropriate for her to use this language in this, but it also gives us a clear picture that she knew what she was doing. She was paying attention. She was listening. She listened for the father to tell her what he had done. She listened for the father to give her some indication that he had benefited from these services in a way that would enable him to parent these children in a different way than these 44 pages set forth for you. So, typically I would just start with the kids, but I just wanted to address that because I think that it's not only appropriate, but actually a good thing that the judge let us know that she was paying attention and that she was not dismissing what father said without hearing it, but hearing all of the information, making that clear and convincing determination, then after that giving father an opportunity to rebut and offer additional information about the ways in which he may have benefited. So I think that covers my argument.
When you describe that, are you describing the decision or what happened at trial?
No, I'm describing the decision, Judge. I think the trial judges mentioned, I believe, 22 times the clear and convincing evidence standard, and I don't think her repetition of it is rote or not conscious, because this is the language that we use. It actually makes my job easier. It makes your jobs easier to know that the judge was paying attention to that standard. And based on the facts that are articulated here that she found at trial, which again are not challenged, the factual basis of those findings is not challenged. What's challenged is whether or not the burden was shifted. And I think the judge's specific language tells us that not only she did not shift the burden, but that she paid attention to contrary evidence and made it clear that that evidence did not serve to undermine her prior decision that the department had shown by clear and convincing evidence that the parent was unfit in this case. So to get back to the children, they are currently 7 and 9 years old. They have been in their pre-adoptive foster home since 2021. So out of their home for 5 years. They've been in their pre-adoptive home for 3. They are ready for permanency. This has been a long time coming for them. I'm just going to pop my glasses on for a moment here. Moving up a little. What we did hear about at trial was from a bonding expert, judges, that served to articulate for the court the benefits that the children had received by being placed in a stable home with loving parents. I don't want to rehash all of that here for you. You all have read the documents. These kids are in a non-chaotic setting where there's not shouting. They are loved They are feeling love, they are very well taken care of. This is not a competition. However, this particular father just didn't have a bond with these children. That was articulated by the judge at trial. It was articulated by the bonding expert. The judge outlined in her findings that she clearly felt that this was in the best interest of the children to effectuate the department's long-term plan of adoption with that current, then current pre-adoptive home. So 3 long years they have been waiting for that. And let's see. One important element of this that I'd just like to note is that, you know, these kids have been through just so much. Your honors have read the record. They've been out of their home for over 5 years now. It's time for them to have some permanency, and they are in a place where they can find that, and they have found it for the past 3 years.
So just the arguments that you made actually went more towards why it's in their best interest to terminate parental rights as opposed to why it's not in their best interest to have visitation. Could you maybe, specifically tailor to the, why visitation would or wouldn't be helpful?
Absolutely, Judge. So the children had indicated that they were in fear of their father. One of the things that they like about their current home is that there's no loud noises or fighting. So there's that element of it, that the children had a negative experience in terms of when they were living with their parent. Also, the father's visitation with the children was very, very scant, not only when he was in prison. So I believe it was 11 instances, in the year before the trial commenced, Dad saw the kids once, I believe, and that's in the record for you. So, counsel is telling me that it's twice, so I will trust that, maybe twice before the trial. So regardless, over a year, and 2 visits, judges and the children are doing very well. Thank you, judges.
Well, thank you all. Actually, a really interesting case, and it's submitted. So we're going to take about a 15-minute break, and we'll be back at about 5 or 10 after 11 to hear the last 2 cases.
All rise. All rise. Now open, as you see it, the body can,
Thank you. We're back on the record. And the fifth case for today is wait for it, 24P232, LANDVATER versus Mass Mutual.
May I begin?
Yes.
Thank you, Your Honor. May it please the court, counsel. My name's Jonathan Feigenbaum. I represent Dr. LANDVATER in this disability insurance dispute. So the case is not about whether or not Dr. LANDVATER is disabled, but it's purely over the amount of the monthly benefits due to her after she turned 65. I suggest to the court that there is no doubt there is a minimal deficit that she's getting underpaid of $2,000 a month, which I will explain a bit more. And if the court completely agrees with Dr. LANDVATER, the deficit is more in the nature of $6,000 a month. So 7 years ago, Mass Mutual agreed.
So let me interrupt you.
Sure.
We're talking about the lifetime rider here, correct?
Correct.
So the original, we'll call it the total disability policy, expired, what, September 11th, was it, 2021? September 14th?
Correct. Correct, Your Honor.
2021. And so no doubt she's totally disabled, no doubt her disability occurred in the time frame in which the policy was effective. You can see that the policy expired, but lucky for Dr. LANDVATER, she purchased the rider.
Generally, I agree with what you're saying, but I don't agree that the policy, quote, expired. It's one integrated document. She purchased the lifetime rider at the time of the policy. You can see it in the application. I'm going from memory. It may be page 111 of the record. And you can see that she purchased the lifetime rider when she acquired the policy in '92.
I don't think it matters when she purchased one or the other, okay? Maybe it matters when she purchased the policy, but how do you disagree that the policy itself says, this is good until the anniversary date after your 65th birthday. So happy birthday, happy 65th birthday, Dr. LANDVATER. On your anniversary date, the policy expires. I don't see how you can dispute that.
Because the policy and the rider has to be read together.
Well, you can read them together, but you can also read each one of them and take its plain and meaning of its words to say, okay, had she not bought the rider, Dr. LANDVATER would have been without benefits. Agreed?
Correct.
Okay. And so now we turn to the language of the rider to determine what benefits she's owed for her lifetime. Do you agree or disagree?
You cannot rely solely on the rider. It's impossible to determine the amount of the benefit without reading the rider and the remainder of the policy as an integrated document. That's what Vermont law requires. That's what Massachusetts law requires.
And that's because the language, the total disability benefit will be the monthly benefit for this rider? Is that the reason why you see?
That's one reason.
Give me another reason why you can't read them separately.
It says, if you look on the rider, it's page 100 of the record. I think it's 16. I embedded it into the brief. It says things like, in general, this rider is made a part of your policy in consideration of the application and premium payments. If the rider is issued after, there's other language in there. I have my list because I kind of expected this question. All right, so it says the rider provides disability benefits, total disability benefits to be paid beyond the expiration date of your policy unless a new definition is specified. All definitions in the policy apply to this rider. That's on page 100. Also on page 100 of the record, the rider, the premiums for this rider are shown on the policy specifications. And the policy specifications are not in the rider. There's also language on the rider that says you also must read this, if necessary, by looking at the COLA rider and the own occupation rider.
So I think in part, we may be arguing about a point that in the end doesn't matter. Because would you agree with me that the language that you're claiming is subject to at least another reasonable and plausible interpretation comes from the language of the lifetime rider?
I agree with you, that's part of the argument, but the other argument, Your Honor, is that the policy facially violates this Vermont Regulation 80-1.
I'm aware of that argument, but that's a standalone argument about the reduction of benefits after age 62 by
Yes.
more than 50% based solely upon age. But when we talk about the clear and unambiguous language and the potential that your interpretation is one of at least one other reasonable interpretation, tell me exactly what your interpretation of that language is to your client. Does it mean that you're reading it that one disability occurred, so at best MassMutual could reduce her coverage from $10,125 per month minus 10%?
Correct. That's it. The policy, the language is unclear. The Superior Court suggested it could be written more clearly. Other courts have made, I believe, the same comment. It is, frankly, a reasonable reading to say.
But why do you say that when if we look at it as a whole, which is what you're asking me to do, we're talking about total disability. We're not talking about somebody who, hurts a finger and then is out for 3 weeks and then comes back and then next year falls and trips and breaks their leg and then restores back to full workability. I mean, we're talking about a person who's totally disabled, and we have no doubt that Dr. LANDVATER, nobody's arguing, is not totally disabled. So this idea of this recurrent disability versus a recurrent anniversary timed with the timing of the disability, it makes it difficult to believe for me that that's a reasonable interpretation of the policy of these recurring disabilities in this time frame.
So let me explain why I disagree, Your Honor. This is an own occupation specialty policy. Dr. LANDVATER is protected if she is unable to do the material duties of an orthopedic surgeon. If she could work as, we'll call it an office orthopedic physician, she could probably still collect benefits. If she could go to law school and become a lawyer, she would still collect benefits. This is an own occupation policy. So it is not totally disabled in the sense that she's unable to engage in any gainful employment. Sometimes people think about.
You can't be an orthopedic surgeon. No, I get that. I get that.
Right, because in her case,
then how do you get to the interpretation that this is recurring disability over a period of time between 55 to 65 that reduces, because the disability only happened once in your case, but you're saying that a reasonable interpretation is that there could be 5 or 6 times in a policy holder's span between the ages of 55 and 65 in which they become unable?
Yes, a fair question. I'll answer it. One, we are cabined by the language, but I'll give you a realistic, let's say at age 56, Dr. LANDVATER had, I'll make it up, lymphoma. She undergoes treatment, she's out of work for 1.5 years, goes back to work. Cancer stays in, there's no evidence of disease for a period of time. 2 years later, it reoccurs. She undergoes another set of treatment. She's out of work again for, we'll make it up, 2 years, goes back to work. You could have some type of medical condition where a person has periods of recovery and returns to work.
Each of which is a total disability.
Each of which is a total disability, and that way you could have multiple disability periods in this 10-year window from 55 to 65. There's also something else I'd like to point about the language that is strange in this policy. It applies to a disability due to an injury or sickness. often in these policies, the declining balance applies to a sickness only. Why? It's this argument my colleague makes about moral hazard. Oh, it's to prevent the person who struggles through work and then at age 64 and 8 months decides to file for disability to get a lifetime retirement. I'll suggest to the court there's no evidence of that here. It was argued in the brief. It was argued in the Superior Court. But here's the problem with that. This policy doesn't make a distinction if the person is disabled due to an injury. So we have to realistically believe that at age 64, if Dr. LANDVATER was down here in Boston, she's not going to walk out in Tremont Street and intentionally get hit by a car and she's knocked to the ground and breaks her hands and then is totally disabled for a period before the age of 65. The language here is very imprecise, and the interpretation I'm suggesting makes sense. A big part of it is, Your Honor.
That same sentence that you just pointed to, like the moral hazard part I wasn't so convinced by, but the first part of that sentence, they say, this is a disability insurance. And it provides more, the rider provides more benefits for insurers who become totally disabled early because they lose the opportunity to have lots of income during that time and build up their retirement. And so we're replacing their ability to save for retirement. The purpose of this policy isn't their retirement benefit.
Right, I agree. But the argument that was raised in the Superior Court, and my friend Mr. Gosselin raised a bit in the briefing, is the reason you have a declining balance on the payments after age 55 is so the insurer doesn't abuse the coverage and treat it as a retirement plan. It's not before the court. It was argued in the Superior Court. It's argued here. If this is Mass Mutual's unexpressed intention, it's irrelevant. It's not in the policy. So if we go back to the language, I mean, probably the most troubling part of it is this comma after the words disability begins. It's followed by after such anniversary. There's a couple ways. Anniversary could tie back to disability, which I suggest that's the fair reading. It could tie back possibly to age 55, but it cannot tie back to policy anniversary because that term is defined in the policy. So the language is very imprecise, and what I'm suggesting is a fair, I'll use the Vermont language.
So you actually anticipated a question I had. I think you may have answered it. If we took the comma out, seems pretty clear to me what it says.
But the comma's there.
No, understood. So yeah. That from your perspective is really the main
That's a
issue
huge part of it.
All right.
The word begins doesn't help either. It actually helps my position. It says disability begins. It didn't say began.
Right.
I mean, the Vermont standard is words or phrases that are fairly susceptible to more than one reasonable interpretation must be construed in favor, liberally in favor of the insured. And I'm suggesting that's the exact case here. If there aren't any more questions, I'd like to go back quickly, though, to the regulation. So
actually, I've got an overarching question about the regulation.
Yeah.
First of all, you know, why did you bring this case why in Massachusetts and not Vermont? I mean, you're asking us to apply Vermont regulatory law, and do you have any cases where Vermont applies Vermont regulatory law to come up to the meaning of a
fair question? I anticipated this. Okay. No, we don't have a Vermont case. Otherwise, we'd both be citing to it. Why is the case brought here? Because if the case has to be tried, because Mass Mutual's here, it requires live witnesses. If the case was brought in Vermont, I'll guarantee it would end up in the federal court in Burlington, and Mass Mutual employees cannot be compelled to testify at trial. And the problem is, for a plaintiff, this happens with some frequency in litigating insurance cases, you end up with a trial by a bunch of deposition testimony. It's not great.
But why is violating a Vermont insurance regulation not just something that that Vermont Insurance Department deals with and not the court? You know, it's a licensing question and not a contract interpretation question?
Fair question. And I can give you a Massachusetts case that illustrates it. These policies are sold and filed. They're filed and then sold. Anyway, occasionally a policy goes through and regulators don't catch anything. There was a case a couple years ago, Aquino here. It had to do with fire insurance policy in Massachusetts, and the policy referred to the insured. The SJC held that word "the" didn't follow the statute faithfully. It needed to be "an," and it made a difference in the outcome because you had co-tenants that owned a home. One naughty co-tenant burnt the house down, and his fiance was able to collect under the policy because the exclusion for the insured or uninsured, it was reversed. Anyway,
but that was a
Aquino
statute.
case.
Was that a statute, though, and not a reg?
It's a statute, yeah, but it's
I
a
mean, that's-
statute, but the reg here, 80, is codified in Vermont. We both cited to it. It's codified in some other section, 4-3- something. So,
I just don't see how you, on one hand, in some ways, it doesn't really matter Vermont or Massachusetts when it comes to the clear and unambiguous argument, right? But the second piece I don't understand is, on one hand, you want us to apply 93A and 176D in Massachusetts, but flip over to Vermont for the Vermont reg. I don't know how you get
because
both.
the adjudication takes place here, I'll agree there is no SJC decision or appeals court decision on that. There's a decision by Judge Salinger that got a fair amount of traction involving an insurance company based here. It's called Constantino. Insurance company based partially in Massachusetts. The insured lived in New York. Judge Salinger concluded that 93A applied because the adjudication took place in Massachusetts. There's a First Circuit case called Riker from 2003. It said, well, 93A didn't apply on an insurance case to a Maryland insured, but the issue really there was Maryland at the time did not allow a private right cause of action against an insurance company. So I understand what the court is saying, but this court is capable of obviously applying an out-of-state law and does it with some regularity. So under the regulation, it's quite clear you can't sell a policy that reduces benefits by more than 50% after the age of 62, and that's exactly what happened here. The counter-argument is, and this is why I kept harping, the counter-argument is the rider is a standalone policy. The Superior Court, I think, called it a equivalent of a insurance policy or something to that effect. It's not. It's impossible to decipher the rider without looking at it as an integrated document, including the entire insurance policy. And anyway.
Okay. All right, well, thank you. I think we'll have to leave it at
Your
that.
Honor.
May it please the court. I'm Jason Goslin on behalf of Mass Mutual. I want to begin with this regulation. It's a Vermont regulation. We have found no cases addressing this regulation in the context of a disability policy and a rider. But you should also know that this was a model regulation. Vermont adopted a model regulation that was circulated back in the late 70s, I believe, and about 15 other states also adopted the same regulation. We have found no case law addressing that regulation in the context of a disability policy and a rider from any other state.
Care to speculate as to why that might be?
I do, because Mr. Feigenbaum's reading of it is incorrect. The regulation states it refers to a specified period of coverage. In this case, it's a disability policy. The original specified period of coverage was from policy issuance until the policy anniversary after age 65. If Dr. LANDVATER had purchased the policy with the standard coverage, that's what most people get. She would have a single specified coverage that goes from when the policy is issued until right up around the time she is hitting sort of normal retirement age. That's the specified period of coverage. Some people have a need for continued income replacement beyond the typical retirement age. And at the time, Connecticut Mutual, Mass Mutual is the successor in interest to Connecticut Mutual. Connecticut Mutual offered this rider that for an additional premium allowed an insured to get additional coverage by way of a rider. That was a separate specified period of coverage that began upon expiration of the policy and continued until the person's life, end of life.
Can you address for us in the rider, the relevant passage, which I will tell you for what it's worth, when I was using my little iPad pen and I read it the first time, I wrote, I'm looking at it now, huh, with 2 question marks, and then I read it 3 more times and I thought I knew what it said pretty clearly. But that seems to me to suggest that maybe it's not quite as clear as it is, the one with the comma, if the insured becomes totally disabled, et cetera, comma, after such anniversary.
Well, so when I read it, the comma doesn't bother me. I mean, in order for a policy provision to be ambiguous, it's not enough that you could write it maybe slightly more clearly. We all know what it's like to write a sentence. You think it's good, then you come back a little bit later and you want to rewrite it. That's what we do. We write and we rewrite all the time. Thankfully, the standard in Massachusetts and everywhere else that I'm aware of is that ambiguity requires 2 reasonable interpretations of a contract. If you have 2 reasonable interpretations, then you have ambiguity. And I would suggest that Mr. Feigenbaum's proposed interpretation is not a reasonable interpretation. And because it's not a reasonable interpretation, we don't have ambiguity, even if, as our trial judge acknowledged, that maybe other writers might have done it a little bit differently, might have sharpened that language a little bit. I'm still not sure I would have taken out the comma, but I understand.
So why isn't it reasonable?
Why isn't Mr. Feigenbaum's? So his reading requires you to ignore everything that comes after the comma. Essentially, his reading of the provision is that if you become disabled after age 55, and then you recover and become disabled again, you have 2 disabilities. Before that, you have 1 disability. And there's 1 reduction for 1 disability, 2 reductions for 2 disabilities, and if you recover and become disabled again, there's 3 reductions. First of all, I don't understand from an insurance perspective why the number of times a person became disabled and recovered from that disability would matter for purposes of a lifetime rider, particularly when this lifetime rider states that any such prior disabilities from which you've recovered essentially are meaningless. This rider only kicks in if you become disabled, remain disabled all the way up through policy expiration, and then you continue to be disabled when the rider begins. So any prior disabilities from which you've recovered really have nothing to do with this lifetime rider.
So as I read this, though, if you live long enough, eventually it's reduced to 0.
I'm sorry, if you
live long enough, eventually, it's incrementally, but it's reduced to 0.
Right. So if you become disabled,
right,
after your the policy anniversary after your 64th birthday, between then and when the policy expires, there will be a 90% reduction. So you'll be getting 10% benefits for life.
Yeah, I get it now. That's on the flip reading. Yeah.
No. So I just want to make sure I'm clear. If after the 7th year, the disability, your interpretation, which you say is the only reasonable interpretation, after the 7th year, between 55 and 65 at 62, then lifetime benefits would be the $3,025 for the rest of Dr. LANDVATER's life.
Correct. So, and that's
never going to move.
Exactly. Going back to why this policy doesn't offend the Vermont regulation, under the first specified period of coverage, the benefits $10,125 every month up until the policy expires, and then there's a benefit calculation period that tells you how much the benefit is during the lifetime rider, and you apply it's essentially a multiplier. It's a reduction of 70%. That's the benefit amount that's due on month 1, and that amount will be paid every month until the insured dies. Dr. LANDVATER is getting that $3,000, whatever the number is. She is getting that now. She has been getting that since the rider began, and she will get that until she dies.
I guess I phrased it incorrectly. Under your reading of this, if the total disability occurred just before the 65th birthday, it'd basically be 0% because it'd be 10% for every year times 10 years from 55 to 65. Is that about right?
No, I think there would be 10%. I think there'd be 10%.
10%.
Oh, it's the other way, I got you. It's the other way around.
So you're always-
reverse. It's the day after, I've got it reversed. Sorry about
And
that.
another point that's worth making, since we're on the topic, if you actually became disabled right before your 65th birthday, the base policy provides a minimum of 24 months benefits. So, and that's happened before, not in this case, but in other cases involving this rider, right on the eve of the 65th birthday, the insured becomes disabled, you will still get 24 months of benefits under the policy, and your rider will kick in and you'll get an additional lifetime benefit so you're actually collecting two benefits at the same time. They are separate benefit provisions.
Let me ask you on a different note, does it matter, Massachusetts or Vermont law? Do you concede that Vermont law controls, Massachusetts law?
Well, I don't think it matters for any of the issues that matter in the case. I think, for, any sort of extra contractual damages, the standard is plausibility and reasonableness. I think, even if the court were to disagree with Mass Mutual's understanding of this contract, the interpretation, which at least, two other trial courts have said Mass Mutual's interpretation was the only reasonable interpretation. If you disagree with that, it's at least reasonable, and I don't think there would be any basis for any sort of extra contractual damages here or anywhere else.
Just to clarify, but you don't take any issue with the fact that we're applying Vermont law, that we could even apply this regulation if the language of the regulation applied, and there's no problem with the jurisdiction here. Those are all
Correct.
fine.
I certainly believe that this court is capable of applying another state's law or another state's regulation. And I think the court should find that this provision does not offend the Vermont regulation because it is not an improper reduction based solely on the insured's age after.
So I want to go back to the interpretation of the clause. So on page 29 of Mr. Feigenbaum's brief, he says this is what you actually are saying that this policy, that this provision says. At age 55, between 56, 90%, 80%. And in fact, when I saw Mr. Feigenbaum this morning, I recognized him from a case we had earlier this year where you had a policy that exactly had that same chart in it.
Yeah.
It was a Paul Revere policy.
Right.
So yours doesn't have that chart. Yours has this very difficult to understand language.
Well, this type of policy is fairly common, and I know the case that you're referring to, the Kleigler case, that had a chart, but it was the same thing. It was a 10% reduction. The specifications page states what the policy benefit is, and then there's a benefit calculation provision in the policy itself that tells you how to calculate the benefit based on the specifications page. Our policy did not have a chart. In my view, what we do have, I think, is clear. And if I can I want to go back to Justice Walsh, your question before. How is their proposed interpretation incorrect or at least not reasonable? And I want to go back to the words. If the insured becomes totally disabled after the policy anniversary on or after his or her 55th birthday. Now, I realize that's a mouthful, and I think that's why our judge in the trial court said, okay, is there a better way of saying that? Those 12 words, those 12 words refer to September 14th, 2011, because that's the policy anniversary date on or after the insured's 65th birthday. So it's a lot of words, but that's what it means. So if you become disabled, totally disabled after September 14th, 2011, the total disability benefit will be the monthly benefit for the rider, so you look at the specifications page, reduced by 10% for each year disability begins after such anniversary. If you wanted to reduce the benefit just based on the number of disabilities that a person had, I think it would say it's reduced by 10% for every disability you've had, or every disability that you've had and recovered from. However, I mean, if an insurance company wanted to make that the basis of a benefit calculation, there would be something relating to the number of times a person becomes disabled. Here it says it's reduced by 10% for each year disability begins after such anniversary. I think it's clear that the reduction is based on the interval of time between that September 14th, 2011 and when the disability began. So it's the timing of the disability.
The anniversary is the September 10th, excuse me, September 10th? Or
September 14th.
14th, 2010. That last word of after such anniversary, the anniversary it's referring to is the September 14th, 2010.
11, but yes. Yeah, exactly. So after such anniversary refers back to September 14th, 2011. So it's reduced by 10% for each year disability begins after that date.
So, pardon me if I'm being obtuse. So then that means, based on the reading here, because she was 62, right? She was 62?
Yes.
So that's 7 times 10, so you say it gets reduced by 70%.
Yes.
But then if she were almost 65, it would be 10 times 10, so it would be reduced by almost 100%. Because...
It would be, well, it would be, so 62...
Yeah, that's what I'm saying. Or depending, does it do it by day or by year? 90%.
I think after 63 would be...
I think I get it now.
Okay.
Yeah, okay.
All right.
I was reading it wrong, but I got it. Thanks.
So why isn't this calculation something that reduces periodic payments on the basis of age?
Well, because it's reducing, it's not really reducing anything. It is a benefit calculation provision for the lifetime rider. And so if you were to say, okay, we're going to disregard the fact that there are 2 specified periods of coverage, the way I understand the policy, the specified period coverage of the policy is inception to 60, let's say 65. It's policy anniversary after 65. That's specified period of coverage number 1. Specified period of coverage number 2 is expiration of the policy to death. There's no reduction. But if you're going to collapse it and say that there is a reduction and that this code section applies, it's not based solely on age because it's based at least in part on the timing of when the disability began as opposed to just age.
So can you give me an example of a policy that would be affected by this disability income protection coverage section?
Well, so I've looked and looked and looked, and I have not found any in the case law, and I suspect because policy forms are submitted to a Department of Insurance, and if something offends it, it will not be approved and it won't be sold. If you had, let's say you had this policy with no lifetime rider, and it said that your benefit will be the amount set forth in the specifications page, but when you turn 62, we're going to reduce it down to 25% of that. Well, that would be an obvious reduction, presumably for no other reason besides age, and that would be impermissible. But we don't have that here, and I don't think, I'm not sure that offensive type of policy exists anywhere because we haven't seen it.
So your point on the Vermont reg is first that it's not applicable because this is a lifetime rider. This is not for a specified period. That's argument number 1. But number 2, even if the lifetime rider could be considered as the regulation applicable, that it doesn't reduce. This is a benefit that began anew and continued for the life. So there was no reduction.
Essentially, yes. The way I see it, there are 2 specified periods of coverage, 1 on the base policy, 1 on the rider. The rider might be less, but it's not a reduction because it's its own specified period of coverage. If you want to collapse the 2 together and say that's really only 1 specified period of coverage, and I think to do that, you would have to disregard some of the language in the Kleiger decision, which also seems to recognize that there is a specified period of coverage under the base policy and the rider. But if you collapse the 2 together, the reduction is not based solely on age. It's based on the timing of when the disability began.
Oh, we gave Mr. Feigenbaum a little extra time. If you want another minute to wrap up, you can. Or you don't have to.
I ask that you affirm. Thank you.
Can I just say to you, when I open up this case, I don't usually say, oh, good, it's an insurance case, but the briefing on this case on both sides is among the best I've ever seen. It was both of you really did an excellent job of laying it out. Completely different points of view, but totally readable. Totally laid out, and not that long. So I thank you both. Really interesting case, and it's submitted.
Thank you. Right.
So last but not least, a case with only 6 briefs in it. CAVANAGH versus CAVANAGH, 23P1461. And so these are cross appeals, and just the way it maybe you put in maybe your notice of appeal first. So we're hearing first from counsel from Michael, right?
Right. I think that we
That's correct.
We viewed ourselves, Your Honor, as me as the appellant, Mr. Cavanagh. Right. May it please the court. My name is Ann Dargy. I represent Michael Cavanagh, the appellant. I reference him as the father for ease of discussion. I think I'd like to start, with this court's permission, with an issue raised largely by entirely by the appellee and recognized in some of the amicus briefs, and that is this issue relative to the mandate rule. I think our opinion on that particular issue is that this is somewhat of a red herring, that it's designed to suggest that the court, in not entering an award for alimony, has violated the mandate rule, and I don't, that's simply not supported. The SJC did not require that in this case, that the trial court enter an order of alimony, simply that the court engage in the evaluation of child support and alimony orders. It was quite specific in the way that it was laid out in that decision. There was a three-step process. I would refer to the rationale, the court's specific rationale, where the court, in fact, did all three of the steps required by the Cavanagh decision and came to a conclusion, the conclusion that the wife was not in need of alimony.
What about the issue of the parameters of the hearing? Because ordinarily it would seem to me that when I read the SJC's decision first, it's go back, here's a narrow question about the prep school, here are the two questions you need to answer, trial court judge. If yes, this way, you go this way. If no, you go that way. And that's the essence of the hearing, and then the rest is all what was the original hearing about?
So I take that question to be whether or not there should have been an evidence or
yeah, that's a better way of saying it. And I know you cited the supplemental rule 401C, which
right, that there shouldn't have been evidence taken on the new numbers. And right. I have to direct you to footnote 31 from the SJC, which specifically required the court to use the 2021 child support guidelines. I think it's important to note that those 2021 child support guidelines did not come into effect until October of 2021. Right. This trial was held, I believe, in June of 2020, July.
Why couldn't you apply the 21 guidelines to the facts of the trial,
for this
hearing? It was really
yes,
not, yeah,
for
trial.
the specific reason that in that footnote 31, the SJC raises a concern about the fact that if we're not looking prospectively at those calculations, that it would trigger an almost immediate need for a complaint for modification, which it would have. In this particular right. case, in that lapse of time, if the judge had done that, contrary to really what footnote 31 describes, if the trial court had entered an order based using 2021 numbers, or I'm sorry, 2021 guidelines on the numbers from trial, it would have required an immediate modification because neither party was in the same financial circumstances that they were at the time of trial. The wife more than doubled her income. Father's income was reduced by his ending the employment at Bay State Medical Center. There were a number of shifts in the parties, particularly the mother's contribution or receipt of retirement benefits, now contributing and receiving an MTRS pension. It would have been, I think to be clear, it would have been an order that wouldn't have ever entered. Even if the judge had done it, it would have essentially, I think, been pro forma, because it would have immediately had to file a complaint for modification because none of those facts currently exist. And both of those facts, the wife's obtaining of a new job, the husband's loss of a job, all of those things are typically what we would rely on as a material and substantial change in circumstances for the purpose of a complaint for modification. So some of it is, I think, an effort to streamline the process, and judicial economy certainly plays a role, to not have to come back and do the exact same trial with the exact same hearing less than a month later, because it would have, of course, been in court on a motion for temporary orders and asking for a reduction, things of that nature. And it appeared in the rescript that the footnote 31 acknowledged that.
So can I ask you, changing the subject, why isn't the wife right, or the mother right, that the result of the way the way the judge did this, ordering only the child support and no alimony, puts her at a subsistence level and doesn't bring her back to the lifestyle to which she was accustomed during the marriage?
Because it isn't true, Judge, I think is the short answer to that. And I think that there's a focus on the lifestyle. I'd like to answer that at least by starting with what the actual income, the net income to both parties after that $650 a week child support order is that wife, in fact, there's a $650 a week child support order and a $20,000 annual contribution from the father to a private school tuition to Williston, Northampton.
Right, but why, and I'm interrupting you, but why is that not separate? I mean, if the child were going to public school, still costs a certain amount for the day-to-day upkeep of the child, if it costs nothing. The $20,000 seems to me is in a separate box because, at least as found by the SJC and then by this judge, there was some agreement or some requirement that the child go to the same prep school as his brothers.
Because it is the reality. It's still money out. It's still money that our client is outputting. And so when you look at his payment of $20,000 annually plus the $650 weekly, even if you don't attach that to the side, to mother's side of the ledger, it's still out on the father's side. I'm not suggesting you add $20,000 to mother's income.
But just for purposes of determining what the actual income of each party is.
Correct.
Okay.
And I think it must take into consideration the fact that when looking at it as a whole, father's out $650 a week, and he's also out approximately $384 a week in that private school tuition. So when it's netted, the father, in fact, nets less per week than does the mother. And if you're then going to compare, so there's a lot of discussion about what the mother's receiving, but I think if you look just at the net income that this order creates, the mother's on the plus side. I think it also bears discussion about the fact that she doesn't live below she's not in subsistence level, and she, in effect, I think arguably is living much closer to the marital lifestyle than the father is at this particular time. She resides in the marital home. It continues to be mortgage-free. The loan on it that you see on her financial statement relates to the fact that she, knowing that the trial court admonished her not to, she took out that loan to fund the private school tuition. That's the only purpose of that loan. It was I think there was some testimony about some other smaller incidentals, but the bulk of that loan was to fund a private school tuition. And otherwise, she is a mortgage-free home. I think Openshaw maybe is a good way, that case is a good way of looking at it. So the parties prioritized paying down the mortgage at this particular time during their marriage, and there was testimony to that in the original trial and to a degree, I think, in the remand trial. Mother has a mortgage-free home. Father does not. There was some discussion about a pool, for example. Father has taken on some additional expenses so that he has access to a pool through a country club, while mother still has the pool at home.
But she doesn't have a pool at home, right? She's got an empty pool because it needs $20,000 in repairs.
Well, I don't know that the court necessarily found some of that credible, but she does have the option to have a pool should she maintain the upkeep.
Well, the judge gave exactly zero for home repairs.
Because it was a $25,000 list. It was $25,000 listed on the financial statement, and after the testimony and after some discussion, it wasn't credible. It was found not credible for a number of reasons.
Maybe $25,000 is overstating it, but it's not nothing.
But to the judge's point, there wasn't enough evidence for the court to make a determination about what it should have been. And it is the burden of the mother to say what it should have been. And it is I would suggest really the sole purview of the trial court to make those credibility determinations, which the court did.
Was that in any way contested? Because it seems to me that it was questioned but uncontested.
As it relates to the
As it relates to
expenses?
what it would cost to fix the pool, the fact that the liner had a leak, the fact that the salinization machine wasn't working, any of the above, the fact that we need a new roof because we haven't had a new roof in a lot of years. I mean,
Right.
Father didn't say, yep, the roof is terrific, and the pool, I saw her swimming in it last week.
I don't think that the specific repairs themselves were not contested. My client wouldn't have had personal knowledge of that anyway, and wasn't the specific issue. I think the specific issue was.
When you say you wouldn't have personal knowledge, just drive by the house. If you see water in the pool, well, it looks like the pool's got water in it.
I don't know if the pool is visible, Your Honor, from the road.
You know, math was never my strength, and it still isn't. You're telling me that father, who's a physician's assistant, is worse off than mom, who teaches in public school in Holyoke as far as income every year?
And it netted out, yes, Your Honor, and I think
that's hard. The math just doesn't work for me on that one. I mean, I'm no ace in math, but not that bad.
So also as a poor math student, it's self-admittedly, the financial statement can be of assistance, and that's in the impounded brief, impounded supplemental the impounded volume 2 to this brief. It's helpful in that the second page gives us the tax breakdown, and one of the biggest issues I think that all family court practitioners at this particular moment are facing is that the higher the tax bracket, the more taxes that are taken out. So the father pays is in a higher tax bracket. He pays much higher taxes. So his net isn't particularly, it isn't as high as I think one might think.
So you argued that, and I didn't quite understand it. And if you could explain to me, and I'm paraphrasing it more nicely, but when you said essentially the SJC doesn't have a clue as to what happens in the real world, I mean, look, true or not, nor maybe the appeals court doesn't either on some level, frankly.
And I will say,
But how does the real-world application of the SJC version of CAVANAGH in context, and I think you mentioned something about Trump's taxes, you lost me when I was reading the transcript. Tell me in plain words what I'm missing or what the SJC missed here in terms of.
so
Yeah. And I'm not saying I'm not suggesting that we don't not have a clue. Go ahead.
it isn't so much, and I acknowledge that comment was made at there's a lot of back and forth at a trial. But the comment really focused, I think
was at the status here. Go ahead.
But I think that the comment sort of directed itself to the fact that the probate and family court is a little bit of its own sort of vortex in terms of it's a constantly changing fact pattern. People continue to live their lives, so they come in with we update financial statements monthly, if not sometimes weekly. And so because you have this consistently morphing set of facts, it is a difficult and sometimes moving target on appeal. And that's really what that comment was referencing. And so I'm happy to kind of, the bare bones of what these financial statements are, give the court an opportunity to see the math fairly quickly. And I'm looking at the Record Appendix Volume 2, my client's financial statement. So this would be beginning on 10 and 11, but 11, which is essentially the second page of the financial statement, breaks down the significant taxes, and then as one looks down the list of expenses, the child support there is included, contributions to retirement account, his contributions to the retirement account, and you'll see in subsection S the total gross weekly deduction, and that comes to $2,289. So that number, and then looking at, it may also be helpful, the expenses that are listed on the third and fourth pages, and sometimes more, are listed there and give us the net weekly income.
If we use the formula or analysis that the SJC directs that be used on the child support, can you explain again why the court only using half of the interest, dividends, and capital gains was not an error? I understand the explanation.
That is part of my brief. I think that the $18,300 that the trial court used isn't proper. I would agree with you.
All right. Okay.
And I have different reasons, but I think we both agree that that $18,300 number is problematic. I recognizing that my time is beginning to wrap up.
We're going to give you extra time.
Okay.
So you.
You're so efficient on the other cases that you luckily get to have less.
But so how you're agreeing with the mother on the the 18,300? Like, how do you say it should be treated?
Well, our position is that that the 18,300 shouldn't be included at all.
Well, that's sort of the opposite then.
Correct. Our position is it shouldn't be included, in part, though, for the same reasons. I think my brother counsel also finds that it wasn't properly calculated. So do I. So does my client. On behalf of my client, I would suggest that it shouldn't be included, and I think there's a thought that
But yours seems to be more numerically driven, whereas theirs is more
philosophical, perhaps.
Yeah, I would say.
And that's right. And
Okay.
So what do you, I mean, a lot of your brief is like, it's not 35,000, it's 34,207. It's not 10,000, it's 9,000 something, 9,870. Like, what, according to you, what should the monthly child support be? What's your bottom line on that?
Well, I think that the issue and the part of the appeal is that what it should have been, really should have been the consistent stream. We should have used the consistent streams of income that he has. So that would be his base salary, the head PA payment, his bonus, of course, and I think there were two other sort of pieces of income that could be considered. I think that we have if you're looking for the specific number, I don't recall what the specific number is that we had proposed. It was certainly lower. I believe it was 475 in that range, if I'm not mistaken, is what the actual guideline was.
$475 as opposed to $650?
I know you're quoting me, Judge, but I don't recall specifically what we had proposed to the court. We ran a number of guidelines because there were a number of ways to do it at that time. So we looked at using portions of the bonus.
Are those in the record somewhere?
Our proposal is not, Judge, but what the court did in the court's work is in the record. I think as it relates to what we were looking at, there has to be this consideration for the significant $20,000 annual payment for private school. And so when CAVANAGH came out, but prior to when the CAVANAGH decision came out, we very regularly ran a number of guidelines. There would be sometimes sets of 3 or 4 different guidelines that we would offer to the trial judge, and then they would, that decision would be made, because there's always factors for every family. Sometimes there's a private tuition consideration, sometimes there's a extracurricular activities or something. Like this family in particular, you'll see in the separation agreement, there was particular consideration given for the high gymnastics costs. So to answer your question sort of in a long way, we've submitted a number of guidelines with.
So, one thing about you on the one hand, you say that the $40,000 should be subtracted from the father's annual income. But on the other hand, you said that the mother made a bad choice to take out a mortgage to pay for that $40,000. And so is that, that's an expense that she shouldn't be able to have, but you should be able to deduct yours?
So, for clarity, I wouldn't suggest that the $40,000, I think that you're referencing is the repayment that the court ordered as it relates to that tuition for the 7th and 8th grade years. And yes, I don't think that should have attached, and we appealed that issue. I think as it relates to the school, there was a complaint for contempt, and there was a judgment on the contempt that wasn't appealed. And whether or not, and there's some discussion about that in both briefs, and certainly by the SJC, whether or not that judgment, we in retrospect, look back on it and think that perhaps it wasn't appropriate, which I think is how the SJC sort of looked at it. It was still a judgment of contempt, and there was significant litigation prior to that judgment of contempt.
Did the SJC say to vacate it?
Pardon?
Didn't the SJC vacate the judgment of contempt?
They didn't. The SJC vacated certain portions of the rationale, but the judgment of contempt was not under appeal.
So you're saying it's a reasonable interpretation of the SJC's saying that this was not a unilateral decision, which was the basis of the contempt, to say, well, I don't have to vacate the contempt. That one I have a hard time with.
So there was a judgment of there was a
Yes.
separate hearing, a separate trial on that judgment of contempt, and it wasn't ever appealed. It was let lie, and we moved forward from there into the complaint for modification. They were two separate actions.
Was that the reason the judge didn't vacate the contempt?
Procedurally, I would imagine, yes, Your Honor, given the fact that it was a judgment that stood, and I don't the only thing that was vacated within the SJC order, the rescript, was the portions of the remand, portions of the rationale.
And the mother's counsel argues that that did not require interlocutory appeal, right? And you say it did.
Oh, so there was a different issue that counsel brought a motion to vacate the appeal after, so the judgment of contempt, I think, entered in July 2020, I believe, if I'm not mistaken. But so it's been the judgment for several years. Right. There was, after the rescript came out, there was a request, a motion filed asking to vacate the judgment of contempt, which the judge then denied. And I think because it was a motion, it should have been an interlocutory appeal.
I know we're well over. Nope.
Just
one more issue.
Real quick. At the end of the day, you claim it's an abuse of discretion, right, what the judge did. What remedy are you asking for? Because I don't see what you're exactly asking for.
So the remedy, the specific remedy would be that unfortunately, that we're looking for the appellate court to give some clarification as to what income is appropriate. What income sources are appropriate to be used for child support purposes, both in this case and because of the nature of the CAVANAGH matter now and the impact that it had on probate and family law practice. We're looking for some guidance as to how that's to be included and how that's to be managed. A part of my brief that was significant was whether or not these capital gains and dividends are included and how that's managed. And so I think, to answer your question as clearly as I can, looking for some guidance as to how the income should be calculated and what pieces are appropriate to include for child support purposes. There's, of course, also this argument that when using retirement contributions, that those are funds that are not readily available to any party. They're not funds that are readily available, funds that wouldn't have been available to care for children, because typically, hopefully, the children have left the home when people are retiring and parents are retiring and using that income for their retirement. They don't typically use their 401k income for child support purposes, and whether or not that would fall under the guideline as a regular source of income. So we're looking for some of that guidance, and with that guidance, I think then the child support calculation can be done. So what I am asking for is a remand with some guidance so that the child support calculations can be made.
Do you have I know you have a position, but on the mother's argument that the judge essentially did not consider that she has more than 2/3 of the youngest child's care?
Yes, a couple of issues with that. The first is that, and again, this is with the way that the Cavanagh decision was structured, we were admonished that not to include or to discuss issues that weren't set forth in the pretrial memorandum, in the pretrial order. So just as a very threshold matter, that wasn't something that was part of the pretrial order. It wasn't on remand, and it wasn't something that was part of the pretrial order in the original complaint for modification. So this concept of there should be this increase because of the parenting schedule is new, unfortunately, on appeal.
You're fully revisiting child support, though. Why is that not part of it? Why is that not a piece of it?
Well, because
I mean, you're suggesting we're not just on a limited, narrow hearing. You're saying, it's going to be modified tomorrow once we do this, so let's just have it out. Let's just, throw it all on the table, figure it out, and let these people after now probably, I think the mother said at some point, we've been doing this for 9 years, so add a few onto that. Let's just be done with this in some form or fashion.
And I think, to Your Honor's point, that is very often how we've handled things, at least certainly in my experience in probate and family court. The SJC decision admonished us from doing that. And one of the things that they vacated out of the court's rationale was very significant testimony about the father's relationship with the child. So it's important, I think, in the first instance to note that this parenting schedule, as it stands by court order right now, is found in the party separation agreement. It's a substantial parenting schedule that my client had. He had every other weekend, Friday to Monday. He had Wednesday overnights, and after mom's weekend, he had a Monday overnight. That hasn't happened. And there was significant testimony in the first trial about why. There was a lot of discussion about the breakdown of the relationship, some very significant concerns from father about the mother's obstructionist behavior as it relates to the children. The court then said that all has to be vacated. SJC said that has to be vacated because it isn't relevant to any of the issues enumerated in the pretrial order. So now moving forward, there's mention in the, and I can certainly find
Did they say that, or did they say there was uncontroverted evidence to the contrary? Or that there was no evidence to support it at the trial?
Not as it relates to the arguments relative to the mother's behavior.
Back again.
As it relates to the parenting schedule. And there are many issues, but the issue as it relates to that, in the second trial, and I can certainly find the page, but in the second trial, there was some attempt and some questioning by mother's counsel about the time that was spent. And the response from trial counsel was, if the court is going to entertain this 2/3, 1/3 concept, then we would be asking those same questions that were asked in that first hearing, because the court, it is now relevant why that time isn't being spent. You have a clear and unequivocal court order for father's parenting time, and it isn't happening. So certainly our client, father, in that particular case, would have a right to have testimony about why it isn't happening.
Why is the why important if the question is the how much? However it comes to be, the question is who's going to pay for what. If it's 0 here and 100 here, or 5% here and 95% here, then that seems to me to say something about how much, and the reasons as to why are a separate issue, no?
Well, because I think that you can't engage.
How much monetarily, not how much.
Well, so I don't know if there's a specific, there isn't a calculation that I'm aware of that says if you're not spending that 1/3 of the time, that here's the new number. I will say, fairly rare that those kinds of deviations are made. They do require written findings, not that I'm certainly not the expert, but I can tell you I haven't ever seen it. It's not typical. But in this particular case, there would have to be some conversation, and father would have a right to put on a case about why he isn't spending the parenting time that he has under a clear and unequivocal court order. There are very specific reasons. Those reasons were enumerated in the first trial. In the second trial, counsel for mother began asking those questions. Counsel for father then said, if we're going down this path, if we're going to have testimony about this particular issue, then I'm going to ask those original questions. And then it was then withdrawn. Said I'm not going to go forward on asking those 2/3, 1/3. And I mentioned it specifically in my reply brief as to the line number. So now on appeal to say I want there to be an upward deviation for the 2/3, 1/3 when there wasn't evidence presented about it, and any of the evidence that would have been relevant to the father's discussion was vacated from the rationale by the SJC, really left in a position that it isn't an issue. It isn't an issue, in our opinion, on appeal. It wasn't an issue at the time of that trial.
I've got two questions. One quick and one maybe long. The quick one is, how old is the youngest child now? What grade?
I think he's a junior. Sophomore.
Okay.
I'm sorry.
Sophomore,
You know,
junior, okay.
I think actually he's a freshman because my client has started paying. He may have just started his second year.
Okay.
Because
So
he is paying the high school tuition.
So conceptually, the mother's brief puts it, this is page 49 to 50 of her brief, says, even if you forget all of our objections to the way the infant was calculated, and let's not count the father's second job, let's put aside the mandate rule, let's go to 2023. If you take the child support payment, the father's paying a differential of, paying 22%, 22.12% of the differential between their incomes. Shouldn't the alimony be used to kick it up into the 30 to 35 range? Why not? Why isn't that a good conceptual way of looking at it?
Oh, two reasons. The first one is that 35, I think that the 35% range that you might be I'm not sure why the 35% range would be the appropriate one. I know that there's this a point in the statute that talks about using the 30 to 35% as the difference between the parties' incomes to assess alimony. That is part of the statute. That has largely not been followed since about 2019 when there was a change to the tax code and alimony is no longer taxable to either party. And I think this goes back to Justice Walsh's original question, mother's receiving some significant tax-free income that father's paying taxes on. So that net is now changed, and it's changed significantly in 2019 when that tax code changed. Okay. So I think the issue is less, though, to answer your specific question, less about percentage and more about the marital lifestyle, is we are trying to the idea of alimony and child support in whatever form, the idea of support, isn't to create a situation where the parties' incomes are equal. That isn't the standard to equate the income. The standard is to ensure that the mother, in this case, but that the recipient of support is living at the same level as he or she did during the marriage. And there isn't, and I realize that this continues to be a point of contention, but the mother still largely lives the way that the parties did during the marriage. And I think it has to be noted that the parties did not live lavish lifestyles. They prioritized paying down the mortgage. Mother has a mortgage-free home.
Okay, no, I think we got that. Okay, thank you very much. We'll hear from mother. And even though you disclaim being an expert on this, I'd say probably the two of you have come to be the de facto experts, but we'll see if.
Thank you, Your Honor. May it please the court. My name is Jeff Goldman. I'm an attorney representing.
Well, can you just pull the mic a little bit up close?
Sure thing. Let me try that again.
Perfect. There you go. Thanks.
I'm Jeff Goldman. I represent LYNN CAVANAGH. A couple things I'd like to outline at the beginning, but wanted to start with a couple of corrections or clarifications of things that came up during the first half of the argument. My client's son is a junior. The party's son is a junior. On the math, which I think is, at the bottom of all of this. According to the judge at the second trial, based on income in 2023 and without prejudice to our argument that that's not what should have been considered, the judge found that Mr. CAVANAGH had employment income of $214,700 and additional investment income, as you observed, of $18,300, which combines to exactly $233,000. Okay, as was also established and I don't think seriously contested, Mrs. CAVANAGH's income on an earned basis was $73,000 a year. The child support that the court ordered was $650 a week. 650 times 52 is $33,810. So if you subtract $33,810 from $233,000 and you add $33,810 to $73,000, you still have a large disparity between the income earned by the mother and the income earned by the father. It's just not true that this was a case where there was some extraordinary circumstance under which the lesser earning spouse became the higher earning spouse. Those are not the facts of this case.
And we shave off, even if we shave off 20 for school, that's 180 to 106.
So if you were to consider that, a deadweight loss from income that goes to no party, it would still be, which again, the court didn't do, but you could. That would be a temporary.
What about the argument, though, that it's not about necessarily straight monetary equality, it's about lifestyle?
That's true, but you can't disregard income from lifestyle. And the SJC was clear on that and said, you cannot calculate alimony on the basis of the party's current spending, especially in a case where the party's current spending is informed by several years post-marriage of making substantially less income than was made or available during the marriage. That's specifically excluded by the court. The other thing I wanted to sort of correct or clarify is the idea that the appellant, cross-appellee, is seeking, quote-unquote, clarification of how to count 401k interest and income. They're not seeking clarification on that. They're seeking a change on that because the CAVANAGH court, the SJC, was utterly clear. It said on page, what is this page? 422, therefore, to the extent the capital gains any income on father's savings and 401k plan included interest, dividends, and capital gains on transactions other than those related to real and personal property, the judge abused her discretion in excluding them from the calculation of the father's gross income for purposes of calculating child support. That seems pretty clear to me. And just the third brief correction is, it's not true that there was no evidence about the childbearing, related expense. I'm sorry, it's not true that there was no evidence relating to the burdens financially borne by each of the parties relating to child care. As we point out in our reply brief, that's just wrong. There's several pages specifically devoted to that in both parties' testimony.
Do you think the judge covered it in her findings?
I'm sorry?
Do you think the judge covered that in her rationale? I shouldn't say
I
findings.
don't believe so. She certainly didn't do it explicitly, and I don't see any indication in the written rationale that it was implicitly considered. More generally, the probate court had to disregard the SCJC's instructions in order to reach the result it did in two dimensions. They're very different dimensions, but I think they're equally important. The first relates, of course, to this case in particular, and that's whether the probate court went beyond its the permissible scope of its authority in purporting to exercise discretion to reopen the record as to the parties. It was initially as to the parties to update their finances, and could be debated whether it was actually limited to that. But even as to that, and also...
Would it have been okay to say we're going to do a limited hearing on the issue that the SJC directed with respect to the prep school, but I need new financials. I need new financial statements from each side?
Whether that could have been done pro forma, I'm not sure I have a position on. I think whether it could be done with the intention of altering the outcome, the answer is no, because that was simply not.
Because by definition, if you got financials, you get to cross-examine on the financials, right?
I think so, and that's, you know, I think by definition of the probate court rules may sort of pro forma require a financial statement each time a party appears. I think in this case, there was no reason to, no other or practical reason to require updated financials.
Well, let me ask you this. To your client's point, again, I think he was in the most recent hearing doing this for 9 years, so I can barely think straight on this issue. Wasn't it in everyone's best interest to get the most current information so that they would not be back a week after the judge made the decision on a modification request? Because it seems to me it would have been inevitable.
Yeah, and I agree. I don't disagree. And I think both at the time this first went back to the probate court from the SJC and repeatedly throughout the proceeding, we suggested that the appropriate way to accommodate that issue would be to allow the father to file a motion for modification and then to have the judge do exactly what the SJC said, to quote unquote recalculate based on, here's what I found, you know, retroactive to 2020 or 2021. And, you know, so this is where the parties stand. And now we're going to accept evidence as to whether there should be a modification of that going forward. And that has two advantages, I think, two legal distinctions between that approach and the approach the court actually took that I think are important and that were required. The first is that Mrs. Cavanagh was entitled to the effect of the judgment that should have entered during the first trial. And that is exactly the import of the SJC's holding. The second is that in order to establish the need for a modification, the father would have had to prove a change in circumstances. And while there may have been a change in circumstances, it may not have been it would have been based on a different standard. On child support, it would have involved the determination of whether the father's decision to stop the second job was something that should be, subtracted from his child support income. And on alimony, it would have been, is there a long-term change in the party's prospects and standard of living that warrants either a temporary or complete reduction of alimony or an alteration of it. But I think that it would have been, I think it was not plausible for the court to reach the ruling it did. Even on the 2023 evidence, it certainly wouldn't have been plausible to bar alimony based on the 2021 evidence. And so you would have been dealing with a modification hearing as to whether there was a significant change in circumstances that would allow, and I think we would have agreed to, a reduction or recalculation of alimony. We certainly wouldn't have, and I don't think the evidence would have allowed a complete elimination of alimony.
Isn't there, and what you'd like us to do now would be say, go back again and do that 2021 calculation, but then if in 2025, father has to file a motion for modification, what are we going to do with the period between 2021 and 2025?
I think that was one of the reasons it would have been wise for Mr. Cavanaugh to file a motion for modification when changes arose, because the first permissible date of a retroactive application of a modification judgment is the date of filing. So there's no, there's been no motion for modification since the motions for modification that were subject to the
judge said, I'm going to consider up to 2023, so that there's really, it's sort of like, there's no reason why the father would have filed that.
Other than if he felt that he needed to do so proactively because, that he knew that was going to be our position on appeal. I take your point. I don't think that we're looking for a result that's inequitable. I think that, we've never been unreasonable in this case, and that a properly instructed court entering a properly informed judgment based on the 2021 filings, I would be hopeful, and there's lots of wood, and I will knock on it, that the parties would be able to agree to a modification appropriate to whatever, alteration in percentage basis of income has happened since.
What is your response to Attorney Dargy's argument about the footnote 31, that it would have been, the 2021 guidelines didn't even take effect until October 2021, so you sort of had to go forward.
Well, that's incorrect as a matter of law, because the 2021 guidelines on their face apply to any judgment entered after their effective date, regardless of when the findings were made. So if the court had, if the probate court had just taken a long time to think about what the award should be, or what the support levels should be, and issued its findings after the 2021 guidelines became effective, it would not have had to hold a new trial to, based on the effectiveness of the 2021 guidelines. The 2021 guidelines were effective as a matter of law based on their date, based on when the judgment issued. So that's what the SJC I understood to be saying. The other thing is, if that was really going to be some kind of deal breaker, or court, we can't understand what you're asking us to do that seems inconsistent with the mandate, then there should have been a motion for rehearing or for reconsideration or for clarification of the SJC, and there wasn't. And I think it's pretty hard to imagine that the SJC wouldn't have thought of that. Just like I don't think it's plausible that the SJC wouldn't have thought that there could be subsequent changes in the parties' financial positions. I think the SJC already, 2.5 years ago, was mindful as to how long this has taken and to how many resources this has consumed on both sides, financially, emotionally, and in every other regard, and wanted it done. And that's unfortunately what didn't happen.
So at the moment, the husband, I presume, is making the 650 week payments, is arranging to pay the $40,000, or is that stayed, or what's going on now?
The current position of the parties is that as far as I know, the child support is being paid at the level the court instructed. There was a delay in paying the retroactive child support. It was eventually paid. The father, as far as I'm aware, is paying the current expenses of the tuition, for the remaining year and a half. But the father has not, despite a contempt order ordering that he do so, has not paid either the $40,000 he was ordered to pay, or post-judgment, let alone pre-judgment interest on that amount.
So, you started with the, let's take the $33,000 that's being paid in child support and consider that a shift of income. And I asked counsel about this too, that why not, try and then, take that as their incomes and then base alimony on that. Is that consistent with the three-step approach of Kavanaugh?
I think it's not precisely consistent with it. The Kavanaugh court determined that this three-step process should be done on its own initiative and without, it was not the process either side had proposed. But under the SJC's
and we're not going to change it.
Thank you.
I mean, that we don't have the power to overrule the SJC, so we're stuck with that too.
I've been waiting a long time for someone to say that to me.
They could, but.
Exactly. And they could have on a motion for reconsideration too, and that would have been the appropriate way to raise a concern about the import of the.
So how would you then, to accomplish what you think should happen or should have happened, how would you apply the three-step?
I think, though the probate court did it, I would say very much in form rather than in function, the three steps that she laid out are the right three steps. The first step is to take alimony as its own animal and assume no child support, okay? She didn't do the last part and assume no child support. But you would say, okay, in a world without child support, the appropriate alimony in this situation would be what it would be. And that calculation would start with young, and which had the extraordinary circumstances of parties with essentially unlimited financial resources. And so you start with young and you figure in a world of unlimited financial resources, this is what it would take for the dependent former spouse to maintain the level of lifestyle that was in place during the marriage.
Not to stop your flow, because I think you're heading in a direction, but you're saying that the judge erred by failing to properly identify the need based on marital lifestyle, and we asked some questions earlier about the pool and the roof, things of that nature. Yep. Why are those not issues of credibility or weight of the evidence that the judge was entitled to look at, weigh, and decide, as opposed to error?
I think it depends on the precise part of the record that we've had, made an issue of. As to the...
So talking about the maintenance on the home.
Right.
As Justice Massing said, it may not be $25,000, but it's not zero.
It's not
or
zero.
Or the pool. Or your response to whether there was actually any evidence to controvert what the mother said about it, and if not, could the judge just say, well, she didn't seem very credible. She was blinking a lot, or she seemed to be uncomfortable, so I just discredit everything.
I don't think that there was a basis in the record for the judge to make a determination that it should be zero. And we didn't suggest in our submission of the financial statement that it should be $25,000 per year. We suggested that there was an arrearage of approximately $25,000 in order to make the repairs that had been long deferred.
This might seem like an odd question, but I'm going to ask it anyhow. Have you two talked at all? When I say this, because you basically got something that neither one of you wanted or suggested. And I can't tell from reading the briefs, but then again, I told you math wasn't my strength, how close the two of you are to what the resolution ought to be.
Well, I have thought from the moment that the SJC entered its decision that we should be done, because we've never taken what we think is an unreasonable position. I don't want to divulge the nature of settlement.
No, I'm not asking you
negotiations,
to, I just
but-
wondered, because I can't
yeah.
tell from, you each asked for, I would just, like, no, who's kind of like remedy, like what's the remedy here? And it's not like, well, remit $150 per month or do this or that. I can't really tell how close the two of you are to agreement versus what we may do or what the SJC has done. And so I don't want you to reveal, I just wondered, are you hemispheres away from one another, or are you closer, like Vermont and Mass border?
I don't want to speak for Ms. Dargy. We had a judicially mediated settlement conference at our request. You know, I thought that we were pretty close to a deal.
Before or after this?
Before,
Okay,
after
before.
the
I saw the reference that in the record.
Yeah, after the I mean, it's in the record. We took the position that it was unreasonable that the father was taking an unreasonable position. That's in the record, and we actually asked for and denied and are not appealing. You know,
But nothing since the judges corrected. I forget what I have it here, but corrected decision and rationale. Nothing.
No, we have not had settlement discussions since then.
Okay.
Okay. No, I.
We made an offer, I think we made a written offer after the judgment came out, and my impression is that we are still.
Miles away. Okay, that's fine. I mean, we can make a decision. It's what we
Right.
get paid to do. I don't have a problem making a decision, but it sounds like the last time when the SJC made a decision, it was something, you know, if you unwrap the Christmas trees under neither one of you had on the list that particularly wanted, you know, right? So
let's finish up with Attorney Goldman. Do you have anything? Do you have any more? Are we have more questions or?
I just want to briefly, and I know my time has expired, and just
you can have a few more minutes.
Call the court's attention to a couple things I think shouldn't be lost in the court's consideration. On the application of the statutory and case law relative to alimony, just very briefly, the SJC in CAVANAGH and in other cases has said the court must consider all relevant factors. And it's elucidated in several cases how to do that. The court explicitly considered almost none of them. You can read implicit consideration into some of the factors, but it certainly did not consider the economic and non-economic contribution of the parties to the marriage in terms of the mothers having supported the father during the education that allowed him to earn the income he now makes. In fact, there was ample evidence on that was not controverted, and that it was just not incorporated into the record. The probate court also failed to consider, at least insofar as it was illuminated by Openshaw and Young, the marital lifestyle, because the court did not consider income, and the court did not consider savings, and the court did not consider debt. And I don't understand how you can have a consideration either of marital...
I'm sorry, the last income savings, what was the third?
Income, savings, or debt.
Net, thank you.
Debt, I'm sorry.
Debt.
I apologize.
No worries.
The court didn't consider what those factors were during the marriage. It didn't consider the ability, the statutory factor of the ability to maintain that lifestyle based on the party's current resources. Instead, the court relied almost exclusively on two non-statutory factors. The first was one that the SJC specifically held should not be considered, which was the availability of child support. You have to do that first step in a world where child support doesn't exist, and the court just got that wrong. The second way the court considered a non-statutory factor inappropriately and also contrary to the SJC's instructions in CAVANAGH was in basing the mother's need on her current expenses. And we knew the judge was going to do that. We filed a motion in limine. We objected at the hearing to evidence on those because the mother's current subsistence expenses at a time several years removed from the marriage simply aren't relevant to her ability to maintain the marital lifestyle as it existed. And that's addressed at more length in some of the amicus briefs. On child support, I think we've discussed that the court disregarded the SJC's instruction on counting income, interest, and dividends, and disregarded this court's holdings as to the consideration of the 1/3, 2/3 assumption. That obviously is predicated on the permissibility of reopening the record in the first place. Finally, I think Your Honor's picked up on our argument as to the reasons that the contempt judgment needs to be vacated. We're not appealing the original judgment of contempt. We're appealing the denial of our motion to vacate the contempt, which I think, as we pointed out in our reply brief, there's no serious argument as to whether we've properly preserved that argument, and the court, in our view, lacked, it was an abuse of discretion for the court to deny that. We also haven't talked about the sanction on me for filing the motion to preclude ad hominem attacks. I want to make sure that's not lost because it has been an issue for me personally. I just briefly state that our motion, which was in the record, was supported both by case law and by the extracts from the trial testimony as to why we thought that motion was necessary.
So, Counsel got 15, so we're in the ballpark I'm going to ask. That was completely lost on me. Any insight you can give us as to why you were sanctioned for filing a motion that, as I read it, didn't seem to be offensive offend any law or offend any ruling that was made, or any sense at all?
I would have to speculate, which I can't do.
Okay,
and I think that's fair enough. That's the reason that the sanction,
okay.
The law is pretty clear that that type of judgment would have to be clearly articulated, and it obviously wasn't. And finally, on interest, I think the briefs are clear, but I can take any questions, and I appreciate the court's solicitude in allowing both parties extra time.
Well, thank you both. Really, really excellent arguments, very responsive, and we appreciate it. It's a very difficult case, and it's submitted. In fact, we'll be in recess for the rest of the afternoon.